So this program today, I view this as a little bit different. It's aimed not at the more experienced people that have spent tons of time involved with patents and trademarks. We aim this at the beginners. We find that when we go out on the road, and we do this about 6 times a year with the Patent and Trademark Resource Center program, we find that if we start off at the very basic level and then go forward, that kind of brings the whole audience in at roughly the same point. So for some of you, this may indeed be a refresher, but for many of you, it will be an introduction to the whole area of intellectual property protection. Before I get started, I do want to thank several people, the state librarian, especially Ms. Carolyn Ashcraft, who we met yesterday. We appreciate the fact that Arkansas State Library is the Patent and Trademark Resource Center for the entire state of Arkansas. Dwayne Gordon, who you just met, the Deputy Director. Michael Strickland, the Manager of the Information Services. Michael's back there. After you leave here today, if you ever come back here, and you need some guidance on how to do patent and trademark searching, Michael's the person to talk to. So, and his staff will be more than happy to help you. You're fortunate to have some well-trained folks here, some very nice, helpful folks here at this Patent and Trademark Resource Center program. I think I also probably should acknowledge the folks, Michael, from the Arkansas Small Business and Technology Development Center. Is Shannon Roberts here? Does she want to? Or Michael Singleton? Would y'all like just to talk a little bit about what's available through the ASBTC? I always need to add that technology part in there. Let me just use that because the people at home are being streamed.
Right. Well, thank you. My name is Michael Singleton, and I'm with the Arkansas Small Business and Technology Development Center. So it's a long name, an even more difficult acronym. So I always say that's why I answer the phone. This is Michael. So I don't have to go through all of that. But we're glad you're here today, and we're also excited to be a part of this event with the Arkansas State Library and the U.S. Patent and Trademark Office. We are an economic development organization that's based at the University of Arkansas at Little Rock. In the College of Business. Our mission is to provide services to existing and new entrepreneurs in the state. We do that through a combination of 3 services that we provide. We provide free one-on-one consulting services, and we also offer training and workshops through events like this today, and then we provide research services as well. We do that through a statewide network that we have, 7 offices throughout the state, all on university campuses. So no matter where you're located in the state, we have someone nearby to provide services to you. Want to once again welcome you today, and then also let you know that tomorrow afternoon, some of you may already be registered, but we do have an opportunity. Another speaker from the U.S. Patent and Trademark Office, Janet Gongola, will be here tomorrow to do a presentation between 1 and 4. She'll be talking about the changes with the America Invents Act. That's recent legislation that makes really sweeping changes to the patent laws here. So she'll be on hand tomorrow. She's the patent reform coordinator to talk a little bit about those and be able to answer any questions that you might have. So with that, thank you. And if you have any questions or want to access our services, you can do that via our website, asbtdc.org. Thank you.
Thank you. You know, I like to acknowledge the fact that we have so many sponsors that worked really hard to do this presentation. Now, particularly, as I mentioned earlier, I want to thank Michael Strickland. When we were talking about putting on this program, the talks for this went on for about a year, and we had some budget problems for a while and couldn't come out here. So we wanted to acknowledge this beautiful new state library building, take advantage of that, but when we were talking about when to come, and we were talking, I said, well, August would be a great time to come to Arkansas because it's so hot and miserably humid in Washington, D.C. at that time of year, it'll be perfect to come here. And, but we appreciate your hospitality. I did grow up in the South, so I'm used to heat and humidity. I'll go ahead and get started now. And so whether you have come here today because you are an independent inventor, or you're an attorney, or you're someone who somehow works in the patent field or the trademark field, or perhaps you're an educator or a student of some kind, we welcome you to the fact that you came here today. And if you came here just because you heard the air conditioning was good in this building, that's fine too. What I'm going to start off with is a very basic overview of intellectual property protection. Neil Masong, my colleague from the U.S. Patent and Trademark Office, will be giving a presentation later on this morning about how to do a thorough job of a preliminary patent search. In fact, everything that you need is going to be right here in this packet as far as what we're going to do today, in addition to, of course, the presentations, which you have a copy of. We're very fortunate that we have the folks from Arkansas Connect who are actually doing a live streaming of this today, which is very unusual for us, and we do appreciate that. So Neil, if we could see the next slide. At the U.S. Patent and Trademark Office, which is part of the U.S. Department of Commerce, there are three areas of business involved. We are, of course, involved with examining patent applications and in so granting U.S. patents. We are involved with the registration of examining federal trademark applications and of registering those, but also disseminating information about patents and trademarks. And that's where the role of places like this library enter. We have 82 libraries around the country. Some are public, some are academic, and some are state libraries. And they are all here to help you, the independent inventor and the small business person. So that's what we do at the U.S. Patent and Trademark Office. One of the, well, we're going to go into some, ask you some questions, see what you might know about us. Next. Ask some true or false questions. I will get my patent application money back if my patent is not granted. Yes, true or false? False. Yeah, it's a shame, but unfortunately, the money that you spend on the application pays for the actual examining of the patent. So, no, afraid not. Next one, I must use an attorney to apply for a patent or trademark. False. We recommend, certainly, particularly with patents, that if you can get the advice of, legal advice of a registered patent attorney or agent, it is quite valuable to do so, but nonetheless, it is not a requirement. You can file pro se if you want to. Next question. There's no way I can expedite examination of my patent application. You're correct. That is false. But that's only been a recent change. We have, in the past year and a half, we have allowed for something called prioritized examination, but you have to pay a fee for that. It's called Track 1. And it's $4,800 for a large entity and $2,400 for a small entity. The U.S. Patent and Trademark Office has a cap of $10,000 that they will take in one fiscal year, and the last time I looked, which was last night, in this current fiscal year, which will end October 1st, we've had about close to 4,000, so that's still a possibility. For people in technology where it is extremely important that you get that patent protection immediately, then that's something to consider. Now, there are a few other ways at the U.S. Patent and Trademark Office that don't necessarily involve money that might expedite your patent application. Those fall into the category of a petition to make special. For example, due to the age of the applicant, it is possible to make a petition to the director. And there's some others as well. We had a pilot program last year that for patents that were involved with green technology that we would move forward in the patenting process. That pilot program is no longer in place. But I do want you to be aware of this, particularly of this new Track 1 expedited examination, because as you probably are aware, many of you may be aware of, there's a large backlog at the U.S. Patent and Trademark Office due to a variety of factors over the years, but there is a large backlog of patent applications, and this is one way to get around that if you need to. Next question. True or false, I can mail a letter to myself with a description of my invention. The postmark will prove the date of my idea to the government and court authorities. Is that true or false? It is false, but it's a very popular urban myth, and I've had people swear that it's true, but it is not true. And that is, the courts have never taken that as evidence of the date of conception of an invention. Next. True or false, a United States patent is an international patent. It will protect my invention in countries other than the United States. False. There's no such thing as an international patent. While we do have treaties which allow for the making it much easier to file for U.S. applicants to file in other countries. That's the Patent Cooperation Treaty that kind of expedites and makes somewhat simpler the matter of getting involved in filing in other countries. If you want to protect your invention in France or in Great Britain or in Brazil, you have to file with the patent offices in those countries. So yes, there's no such thing as an international patent. And there's also no such thing as an international trademark either. Next. I have to pay to use the resources of a patent and trademark resource center such as the Arkansas State Library. Oh, yeah, that's correct. You do not have to pay. You may have, now granted, you might have to pay for parking. I can't promise that. You might have to pay for parking, and you might have to pay for to print out copies of patents that you find here. But as far as actually use the resources, they are freely available to you as a citizen. Next. Librarians at these libraries will help me complete my patent and or trademark application. Well, they cannot provide legal advice, and therefore they cannot actually help you complete your application. They are there to show you the resources that we make available to customers such as you, but they will not give you legal advice. Only attorneys can provide legal advice. And you will see later, as Neil gives a presentation on patent searching, and as I give a presentation on trademark searching, you will see the step-by-step process that a librarian at a patent and trademark resource center can show you how to do a search without actually doing the search for you. Next, that's it. So what is intellectual property? That phrase sometimes confuses folks. Broadly, it's a product of the intellect that may have commercial value. And in not only in the United States, but all countries around the world, there's a whole body of law involved in protecting intellectual property, just like there's a body of law to protect physical property. The four general ways of protecting intellectual property are, of course, patents and trademarks and copyright and trade secrets. The U.S. Patent and Trademark Office is really not involved at all with copyright outside of we do provide a function of giving advice to the executive branch on areas of copyright. Registration of copyright is handled by the Library of Congress, and it is to protect original works of authorship which are fixed in a tangible form of expression, such as literary works, musical works, dramatic works, works of choreography, commercial art, graphic works, motion picture, sound recordings, architectural drawings. Now this, with copyright registration, with copyright, it provides a bundle of exclusive rights to the copyright owner, as you see here. The right to reproduce the work and prepare derivative works, to make copies of the work, to present it publicly if it's something that involves either a public performance or displaying something publicly, or to authorize others to do so. The copyright fees, compared to patents and trademarks, registering copyright is cheap. And as you see here listed here, they do give a less expensive price if you are filing electronically. The type of, they have different forms based on the different types of works that are being protected by copyright. The value of actually registering, the benefits rather of registering not only is it, as librarians, we know the value of it is the fact that you're establishing a public record for future generations to know about the work. But if you ever want to go after infringers, people are actually copying your book or copying something off of your website or copying your sound recording, you will need to have a registration to be able to go after infringers and get some type of financial recovery. Also, the U.S. Customs Service, they will get involved in preventing something to be brought into the United States that is a counterfeit copy of something if you have copyright registration. Now, another area, a whole other area is trade secrets. What is the federal agency involved with the registration of trade secrets? Pardon? There is none. It's a trick question. That's right. It wouldn't be a secret if there was a federal agency involved with the actual registration of them. The value of a trade secret is, we will see in a second, but what is a trade secret? Or rather famously, the formula for Coca-Cola, which is supposedly in a vault somewhere in Atlanta, or the original secret recipe for Kentucky Fried Chicken are examples of two types of examples of trade secrets, things that have been maintained as trade secrets. However, it's really much more than something like a recipe or a formula that can't be. It's actually any type of information that's used internally at a company that is used by a business that provides them with an advantage, a business advantage over competitors. Now, as you see on the next screen, some of the advantages of trade secrets. Of course, there are no fees, there's no registration involved. There's essentially no time limits involved as long as you can maintain it as a secret. Now, there are laws out there, both at the state level and both at the federal level, to deal with stealing of trade secrets. Let's say an employee of a company who goes to work for another employee, and if they happen to have access to the trade secret when they are at that one company and they divulge it to the other company, there are laws to go after that to prevent that from happening. But again, that's the power of a trade secret. If you use something that you can maintain as a secret. Now, Ms. Angola will speak tomorrow about the new America Invents Act. There's actually some additional power that's been given to the maintenance of trade secrets. If in the past, if you had a trade secret and then an individual turned around and independently of their own patented the thing that was your trade secret, they could turn around, if you continued to use it, they could turn around and sue you. But there's something new or newly involved in the new legislation called prior user rights, which actually protects the commercial use of something that's a trade secret. So just bear that in mind. It's something that gives additional power to trade secrets. Next. Now, patents. This is one of the two areas that the U.S. Patent and Trademark Office is involved in, of course. So here's the definition of a U.S. patent. It is a property right that's granted by the U.S. government to an inventor. And notice what I've got highlighted there, to exclude others from making, using, offering for sale, or selling the invention throughout the United States or importing into the United States. Notice that word exclude. What does that mean? It means you can sue them. You can take them to court and sue them if they do those things. It's not saying you can make that thing. Rather, it's saying it's an offensive right. You can actually go to courts and possibly get triple damages or statutory damages of some kind. But the catch is it's a trade-off. You get this monopoly right for a limited period of time, this right to exclude for a limited period of time, and the exchange is that you provide the rest of the world with information on how that invention works in the best mode possible so it is be understandable to someone of ordinary skill in that art in the patent application and what might ultimately be published as the issued patent. So this exchange and this is kind of the power of the patent system, that the fact that people can read patents, understand your invention, and then in turn make improvements upon inventions. Though you do have a monopoly for 20 years and you can enforce that monopoly, people can make improvements upon your idea. Now, if they are making improvements upon your idea and you're an enforced patent and they're using technology that is in your patent, they may have to go to you and pay a licensing fee. But nonetheless, this is kind of fuels the progress involved in the world of inventions. So what types of things can be patented? Well, here are the variety of things. A machine, an article of manufacture, processes, compositions of matter, and since the late 90s, business methods, or any new or useful improvement of the above. For this, we're talking about utility patents, and the protection is, under current law, 20 years from the date of filing the application. An example is the Segway that you see right there. Another example that you may not have been aware of are design patents. Design patents don't protect how something works. They protect an article of manufacture, the ornamental design of it, how it looks. So for example, those chairs you see over on the right, those chairs can't be protected by a utility patent. They don't do anything unique, anything new or non-obvious. What can be protected is the unique look of them. In fact, all of those come out of the Museum of Modern Art's catalog. Now, if I came up with the very first chair that had a reclining mechanism for the back or lumbar support or a built-in heating element, then that would qualify for a utility patent because functionality would be protected. But if it's just the look for something, a look of something, design patents fall into play. Athletic shoes are another example. That toothbrush holder looks like a banana. It looks unusual, right? It's unique and unusual. But what's being protected is merely the look of it. Not only is only the appearance protected, there's no functionality that's being protected, but also the term is different. In this case, it is 14 years from the date that the patent issued. Now, Steve Jobs is an example of someone who had a lot of design patents. And you may think, oh, a design patent isn't that important. But actually, if you think about it, in today's environment, a lot of times the decisions we make as consumers oftentimes is not always based on how something works, but how something looks. So don't disregard design patents, but just remember that the protection is only limited to the ornamental look of something. It is not unusual for some companies to protect both the look of something so it won't be copied, the look won't be copied, but also the functionality if it's something that qualifies for utility patent protection. And finally, a very small area that you may not be aware of, but plant patents. And that is, these are for new asexually reproduced plants. And this is the only type of patent that we still send to libraries in a paper copy, because oftentimes what's being protected is the color variation of the plant. So if you're in the horticulture industry or something like that, it may be of interest to you. Now there are, in the utility patent world, there are some plant-related patents, things like genetically modified corn and that sort of thing. That's a whole other area. What we're talking about here are new varieties of plants. So what cannot be patented? I've shown you some examples of things that can be patented. What are some things that cannot be patented? Well, inventions that are not new, that is, lack novelty. I can't go out there and get a patent on something that was previously invented. Once it's been patented, it's been publicly disclosed in a patent, and you can't turn around and get a patent on it. You can make an improvement on it and possibly get a patent, but once it's been patented, you cannot get a patent on it again. Inventions which were made public more than 1 year prior to the patent application filing date. In the United States, we have what's called a grace period. If there is public disclosure of an invention, then there's a 1 year clock that starts ticking, and you have that 1 year in order to get your patent application with it to the U.S. Patent and Trademark Office. It can be a provisional patent application. It doesn't have to be a non-provisional patent application, but nonetheless, you have 1 year or you lose the opportunity to get a patent on something. Now, the new AIA Patent Reform Act has some ramifications on the grace period, and I will let Ms. Gongola talk about that. Inventions which are obvious variations of known technology. Now, we're not talking obvious variations to the average person in the street. We're talking about obvious to somebody who is an engineer in that field, let's say. The terminology we use is one of ordinary skill in the art. In fact, one of the interesting things that I found coming to work at the U.S. Patent and Trademark Office are the people we hire as patent examiners. We hire engineering students fresh out of university. Why? Because they are of ordinary skill in the art. Now, of course, we train them to, they go through, what is it, a 6-month or 8-month training session so they can apply patent law and use their expertise. And over time, they will become much more expert at a particularly focused area. But nonetheless, it's of ordinary skill in the arts. So this whole area of obviousness is really a crucial area, because many times, while your patent application may meet the criteria of being your invention may meet the criteria of being novel, it may not meet the criteria of not being not being obvious to one of ordinary skill in that art. It's a complex area that the courts continue to refine. A simple example I can give you is such thing as a computer mouse. Let's say that I thought it would be a clever idea to come up with a computer mouse that was 1.5 times the size of the typical computer mouse for people with large hands. Well, it would be an obvious improvement in technology using what's already commonly known. It wouldn't be something new and unexpected that would result from that, and therefore that would be rejected because it would be merely an obvious improvement. And inventions must have use, but that doesn't mean they have to be practical. We don't mean that. We mean it meets the statutory definition of use. And such things as laws of nature, physical phenomena, and abstract ideas cannot be patented. You hear the term patent pending. What does that mean? Well, all it means simply is that a patent has been applied for at the U.S. Patent and Trademark Office. It may be a provisional patent application, but that is all that it means. The inventor has applied for a patent, and typically in those cases, if they are putting the invention out there in the marketplace, they may be using that terminology on the packaging essentially to warn possible infringers that they do have a patent application on file with the U.S. Patent and Trademark Office. And that's all it can mean at that point. You can go after infringers once you get the patent, but with patent pending status alone by itself, you cannot go after infringers. So the idea is to discourage others because you are in line to possibly get a patent. So what are the costs involved with a patent? Well, patents aren't cheap, and the cost of patents have gone up. Filing for a patent have gone up with the passing of the America Invents Act. They went up about 15%, many of the different costs involved. But these are the fees right here, 15%. Yes, and these show that increase. These are the costs that I show here in this slide that are available to inventors who are applying who are small entities. So what's a small entity? Well, small entities get half off, so that's great. A small entity is an independent inventor. It may be someone working for a company that meets the SBA, the Small Business Administration's criteria of a small business, which I believe is 500 or fewer employees, or a nonprofit. And nonprofits include universities. So that is the small entity cost. Now, the one additional thing I would point out is if you file, the initial filing fee, if done electronically, is dropped down to $95. So over the life of a patent, the first 3 bullets here, initial filing fee and search fee and examination fee, typically all of you would have to pay if you filed for a patent. And then the issue fee would only kick in if actually a patent issued. And then over the life of the patent, there are 3 points in which maintenance fees kick in. If for some reason you're not having success in commercially exploiting your patent and you choose to not pay those maintenance fees at those intervals, then the possibility exists that then what will happen is you will abandon your patent and it will go into the public domain early. These fees are subject to change, and so the link here, please always check the U.S. Patent and Trademark Office's website for any changes in fees. Now, some of you may have heard with the American Invents Act that there's a whole new category of fee discounts involved, and that's for micro-entities. So I want to tell you a little bit about micro-entities. With the passing of the America Invents Act, it allowed for a new category which has even an additional discount. And that additional discount is a 75% discount. Remember I said that small entities were 50%? Well, micro entities are 75%. This has not gone into force yet. The what the rules have been, the criteria have been published in the Federal Register. This may not, from what I have read so far from the USPTO, this may not take place until actually next spring, but it is coming. So I want to tell you the 4 parts of what makes one qualify as a microentity. For one thing, in order to qualify as a microentity, first you have to be a small entity, and I told you what the criteria were for small entity. You cannot have been named as an inventor on more than 4 previously filed applications, patent applications, and those are non-provisional patent applications. Your gross income cannot be more than 3 times the median household income in the preceding calendar year. You cannot have your patent application, it cannot have been assigned, licensed the application to an entity that exceeds that gross income limit. This does include, as possible inclusion as a microentity, it does include applicants employed by an institute of higher learning. So that's something to consider. It is coming, but it is not quite here yet. And any more questions on that, feel free to ask Ms. Gongolo tomorrow. One of the things that is very important to applicants is to know the value of an early priority date. So I want to talk about that briefly. You may have heard the term prior art. What's prior art? Well, prior art's going to be art that is public disclosures of technology prior to a certain date. And this is the date we're talking about when we're talking about a prior art or priority date. Under the current law, because currently we are still under the operations of the previous law, and that is America is still a country that is a first to invent country. We will switch over to a first inventor to file country on March 16th of 2013. But that hasn't happened yet. So under current law, unless an inventor files evidence that their invention was actually made earlier than the application filing date, this filing date is what serves as the date before which any publications, public use, or sales may serve as prior art against the invention. So anything prior to that, what will be in the future, the filing date, that's what they're going to be looking for to see if your patent and the claims in your patent application meet those criteria of novelty, is it new, and non-obvious. Now what is in prior art, if you'll see in the next slide, a variety of things are considered prior art. Now you might think of U.S. patents, sure, but also non-U.S. patents can be brought into play. Think of, my goodness, while there are 8 million U.S. patents, there are over 20 million patents in general all around the world. And not only patents, but published patent applications. Such things as journal articles and conference proceedings. Engineers go to conferences and they give presentations that sometimes disclose inventions and how inventions work. Websites, these TV shows that you see on TV where, like Shark Tank and all of these others where people go up and they give presentations. These are all public disclosures of prior art. Dissertations, websites, the whole body of technical knowledge that's out there. That's the amazing challenge involved with doing a thorough job of a prior art search. There's so much involved, and because of that challenge, many times when people start with prior art searching, they start off with what's a manageable thing, and that is U.S. patents. And since March of 2001, we've been publishing patent applications. But there is a lot more, and the patent examiner at the USPTO can cite those against your patent application by saying, they can say your patent isn't novel because this person in this country published it. Now, one of the advantages is of the fact that we have such a, the U.S. is such a powerhouse as a world economy. Most major inventions companies, at least that can afford to do so, will not only typically file in their own country, but they will try to file in the United States. But you shouldn't, don't let that give you too much comfort in thinking you're doing a thorough job of a patent search if you're only covering U.S. patents and U.S. published applications. Now here at the Arkansas State Library, our librarians here are going to focus on that, but they can show you, not in as much as thorough coverage, but they also show you some of the sites where some of the foreign patents are available as well. An example of that would be the patent site of the European Patent Office, the ESPOSNet website, which maintains a worldwide database. Another thing that's available here at this library is something called the public version of the web-based examiner search tool, PubWest. PubWest has patent abstracts of Japan and patent abstracts of European countries that are available. So there is a way to expand your search in that, and based on the different libraries that are involved in our network, some of them have additional databases to allow searching other types of technical literature as well. I mentioned that patents are intellectual property. Well, they have some of the same characteristics that physical property do. But it's just because and we can apply those as well. For example, you can sell your patent outright to someone else. The term that's used is called assigning it. Or if you have a case where, as a work-for-hire situation, if you're an engineer who works for a company, then as part of your work agreement, you've already assigned it. Anything that you invent on the job is assigned to that company. It would be listed on while your name as an inventor would be listed on the patent, that company would be listed as the assignee on that patent. But the day after a patent issues, you can turn around and sell it to someone else. Now, another thing you can do is, rather than selling your patent to someone, you can choose to hold on to that patent but license it out to a company, perhaps for a limited period of time, and receive any royalties on that. This is a particularly popular approach for folks that may not have the financial backing to put the product out there on their own. Also, if the patent is in force and you pass away, you can leave that patent to your heirs or whoever you choose to leave it to. This is the U.S. Patent and Trademark Office website. The website was redesigned back in last December. We'll be showing you throughout the day, particularly focusing on the areas involved with the searching areas. But if all of your questions related to the American Invents Act, if you click on that link in the middle for American Invents Act, it will take you to a microsite, and there's a way to subscribe. I don't know if I have a link to this, but we have a way to subscribe to that because, as I said, this complex law, as some of the new guidelines have been announced or been published in the Federal Register, we can send you an email saying, hey, this is the latest stuff that's coming out. There are many new things that are coming into play that are going to start being enforced as of the middle of September. So a lot of new things coming up as well. I told you about the expedited patent processing, that Track 1 patents. Link there is for that. In the top right-hand corner, you notice we have links for searching for patents and searching for trademarks. And we'll be using that a lot in the presentation that Neil will have shortly on the multi-step process and doing a patent search. Next. We have on our website two very basic searching databases. PatFT is for issued patents, goes all the way back to 1790. It has the images of all patents going back to 1790. But as a text search, it only text searches patents back to 1976. We sell our data to companies, and in fact, Google buys our data, and they use optical character recognition to scan older patents. And while they say they have searching capability back to 1790, due to the way characters are in earlier patents, they really don't cover that. But I've been able to find, using some text searching, all the way back sometimes to the 1800s. Here at this library, through the PubWest portal to databases, they have access to the OCR scanned patents that the U.S. Patent and Trademark Office has available internally and has available at our public search room, and that goes back to 1920. Depending on your technology that you are interested in patenting, you may very well need to look at patents prior to the 1970s. On the other hand, if you're in a brand new technology like nanotechnology, you may not have a need to take your search back, but particularly in the area of mechanical patents, there's typically a need to look back at earlier patents. How do you get around that? Well, Neil is going to show you in his presentation how to do classification searching, because on our PatFT website, you can go all the way back to the very beginning using classification searching. In fact, I tell people this. I used to be at Arizona State University for 5 years, and we had a patent attorney who came in who had done a keyword search. And now we live in a Google age, and we expect to do, we hope to do just putting in keywords, defining everything we need in a patent search. He had a customer who had invented a new gardening tool. He did a keyword search on the USPTO PatFT website, came up with 0 results. But he remembered that it stopped at 1976. So he came in, we worked with him, he found an appropriate classification, U.S. patent classification for this type of gardening tool, ran the search. And indeed, back in 1921, that exact gardening tool had been patented. So there was no way the customer would have been able to have gotten a patent on it. So they saved themselves a lot of money by the fact that the patent attorney had done that search. And you can do searches like that as well. Now, there's something else listed up here called AppFT, and those are published patent applications. Typically, unless an inventor opts out of it by saying that they are not going to file their patent in a country that has 18-month publication, which is an option. Most of our patent applications now are published after 18 months, and they are published in this particular database, AppFT. It's a separate database. Next question. It is considered a public disclosure, and therefore it is considered possible prior art you should consider. Now, our patent images, unfortunately, on the USPTO website are in TIFF format. While this is a very high quality image file format, most PCs don't come with TIFF viewers. We have on our website links to 2 third-party TIFF viewer companies, Alternative, Internative, which you can download to your PC. But if you are looking at the text of a patent and you click on the button that says images, you're not going to see the image unless you have a TIFF viewer on your PC. We sell our data to different companies. Among them is Google. Google has patents in a PNG format, but also has a PDF download button on there. So you can consider that. There's also another free website called Free Patents Online, freepatentsonline.com. And finally, the European Patent Office's website on their worldwide database has U.S. patents, and those are in PDF format. So there are other options available to you if you can't figure out how to get a TIFF file viewer, but it is possible. I've got it on my home computer. It's not that hard to do. Customers tell us all the time they want to have things available in some other format that's TIFF, and finally, we've got some money that's available now that we'll go towards that. As I understand, within the coming year, maybe quite soon, as a matter of fact, we will go to not the PDF format, but the PNG format that Google has on their site. Next. We have a separate database that you may not be aware of. It's called Public PAIR. PAIR stands for Patent Application Information Retrieval. Once a patent has been, either a patent is issued or in the case of 18-month publication, then the file, the actual file wrapper, the electronic file wrapper will appear that anyone in the public can view, but only once there's publication. Prior to that, it is only available to the applicant or the attorney representing the applicant if they have an attorney representing them. These are all what I would say is paperwork, but now things are done so much electronically, there's really not a lot of paperwork involved. But this is the back and forth between the applicant and the U.S. Patent and Trademark Office. You can see where the application, what's gone on so far with the patent application. You can see if a patent examiner has examined it, if they sent a first action letter, if they raised any objections. If so, how did the applicant or the attorney representing the applicant address that? Now, this started about 7 or 8 years ago, so that's as far back as it goes. Patents prior to that are not available electronically on the website, but you can request copies be made for a fee for earlier patent files. but these are available for free, and this does not require TIFF viewers. These are, these are things that are in PDF format. So if you're entering a new field and you want to see the patents that have issued in that field and get a sense of what was involved in the whole process with patent examiners, this is one way you can check. The way you get into this is you need either a patent number, or if the patent hasn't issued, the serial number involved, or if there's a publication number after 18-month publication. Basically, you need a number to get into this. If you need help with this, the librarians here can show you how to get into it. Next. And the other area of intellectual property protection, trademarks. Trademarks are names for words or some other device that are used to distinguish products or services from other products, services, and services in the marketplace, and to act as a source identifier. Those are some famous ones right there. A trade name is not necessarily the same thing as a trademark, but it may be used that way. However, for example, the automobile Subaru is a well-known trademark, but the company that produces it, Fuji Heavy Industries, never uses that name as a trademark in their advertising. But Pepco Holdings Company, which is the name of the power company in the DC area, the District of Columbia area, they do use their trade name as a trademark. Trademarks is an umbrella term, specifically if you're using services, intangibles, they're called service marks. And then if they're goods, trademarks, kind of a small t. For example, Delta Airlines, air transportation, services, Bank of America, financial services, H&R Block, tax preparation software services. Not software, but services. The use of the R with a circle can only be used if you have registration, federal registration of your mark. But if you want to indicate to the rest of the world that you are using your product, the words you're using on a product are being used as a mark, you can indicate so with a small TM if it's a product, or a small SM with a service mark. It doesn't necessarily mean you have a pending application. It means you're just showing the rest of the world you're using a mark as a mark. So some examples of some well-known trademarks. Marks can be words or letters. Even, you see at the bottom, you can have slogans as used as trademarks. Next. A much smaller area of protection, but we all are familiar with the colors on John Deere products, John Deere green and the yellow. Well, if over time colors have been acquired distinctiveness with a product or a service, or the color brown, for example, with UPS, then you can show that that color mark has acquired distinctiveness and can possibly get trademark protection. Another area, logos by themselves, without even any words, can possibly be powerful enough to be a trademark. Or, as we see on the next slide, a combination thereof of graphic elements and words, what we call composite marks. There's some other smaller areas that I don't show you. There's some areas called configuration marks and sound marks. But those are kind of the basic areas that we talk about when we talk about trademarks. There are broad areas of trademark protection. By the actual fact that you're using a mark on a product in commerce or in advertising for a service, then because you're using a mark, you have common law protection. You can choose, however, if you're using your mark only within a state, to get a state trademark. And in this state, it's the Secretary of State's office that is involved with state registration. If, on the other hand, if you're selling your goods or services in interstate commerce or outside from the United States outside, then you can get federal protection because after all, the federal government is involved with interstate commerce. Or if you're selling something on the internet, are you selling in interstate commerce? Of course. So nowadays, that distinction where you might only have a business only focusing in one small region of a state is changing more and more as we sell things more and more online. But in that case, you can get federal registration with the U.S. Patent and Trademark Office. Common law marks, where do you find them? Such things as telephone directories, newspapers, or in web search engines. That's the only place you can find them because there's no registration of them. State trademarks, this is an example from the Secretary of State's office here. And one of the great things about the Secretary of State's office here, they actually have a searchable database. Not at all of the Secretary of State's office have a publicly available searchable database, but your state does. And, of course, federal trademarks. And we'll get into that this afternoon about how to do a thorough job of a federal trademark search. There are various benefits associated with federal trademarks. You have a list on the left hand in your booklet about all the benefits involved. The key here is that while the rights are associated with the use of a mark in commerce, there are benefits associated with registration at the federal level. Most particularly the fact that you can go after infringers much more easily because certain things are understood if you have federal registration as far as your ownership of the mark. And you can also, remember I showed you that slide about getting the Customs Service involved. If somebody is bringing counterfeit copies of your product or service into the market, into the United States, you can get the Federal Customs Service involved. So again, the rights arise from actual use of the mark in commerce. There are benefits from registration. And by the way, those rights can last indefinitely. Remember when I was talking about patents, I said patents expire. Trademark rights can continue theoretically indefinitely as long as you continue to use the mark in commerce, and if after every 10 years you renew that mark with the U.S. Patent and Trademark Office as related to federal trademarks. So let's compare these. In general, of course, patents protect inventions. Trademarks protect words or some other device that are used on products or services sold in commerce. A patented invention may never make it into commerce. There's some wonderful ideas for inventions that got patents on them, but perhaps the inventor was not able to get financing to actually get it into commerce. On the other hand, with trademarks, trademark goods and services, in order to get registration, they have to show proof that they are actually, if it's based on use, they have to show specimens showing it's actually being used in commerce. Patents, the length of protection, intellectual property protection is limited. Trademarks, theoretically, it can go on. For example, Coca-Cola. Coca-Cola is an example of a very old trademark that's been out there for over 100 years. Patents are only issued at the federal level. Trademarks can be issued at the state level as well as the federal level. Registration is that is. And comparing the two, patents are much more complex to get right, to file for. You can do it on your own, file on your own, but they're much more complex and costly compared to trademarks. Over 30% of the filers for federal trademark registration apply on their own, so that's a big difference there. And just want you to be aware that on the USPTO website, we do have independent inventor web pages. So if you are an independent inventor, please take a look at these pages. They've been particularly designed for the types of questions you may have. We're going to talk about one of those later on this morning, about how to look out for being scammed by invention promotion companies. This video is on the Independent Inventors website. It's a good starting out point to get advice from John Calvert, who is the head of the Independent Inventors Program, good practical advice, and Tony Knight, who is with the Solicitor's Office. Told you about the American Invents microsite? Yes. That's where it's at. And finally, like many organizations or companies, when we have customer contact centers to initially go through if you have questions. So that's that's one place to go to, as well as, of course, the Arkansas State Library. And I made a mistake, and I'm going to be punished for this. I said, I think on the form that you have, I said Arkansas Public Library. I changed it when I realized it the other day. It's Arkansas State Library. And of course, feel free to come here for your questions. Now, before I take any questions, we do have someone here from an inventors group. One of the most powerful local resources you can have, if you're fortunate enough to have in your area, is to have an inventors group. And here in Arkansas, you do have an inventors group. So Chad, if you want to come up here and tell the folks, because I know you have to leave early today, you might want to, you get a free plug.
Thank you. Thank you. Thanks, Tom. Thanks, Neil. Again, as Tom introduced me, I'm Chad Collins. I'm the founder and kind of the only guy that's involved with the Arkansas Inventors Network. It's a network, not a club, not a group that does anything but brings inventors together, or folks that have ideas, and these can be folks at companies, they can be individual inventors, anyone that's got an idea that you're looking to try and commercialize. How many in here are independent inventors or are folks looking that have an idea that are looking to get that idea off the ground? About half of you. That's what a lot of folks come up with, an idea, and an idea is just that. It doesn't become anything that can be monetized until someone else pulls their wallet out and gives you money for it. And what Tom and Neil are here talking about today are the intellectual properties, the protections that you need so someone doesn't take your idea and make money with it on their end. And so many independent inventors I meet are very worried about someone else taking their idea and running with it. And these guys, whether you can, how to search for a patent, how to search for a trademark, I look through the presentation that they're doing, and that's information's golden, and it's stuff that I've used over my years to make sure that an item can be patented, or if you can get a trademark for it. But I have taken products to market using both, they've been patented, they had no patent but a trademark, and then I've taken products to market that had neither a patent nor a trademark because you just couldn't, it just wasn't physically viable to make that happen. I'm a consultant. I help inventors take products to market, and I came across folks that just, they didn't have the money, they didn't have the time to have me do it, but they needed help. So I helped establish the Arkansas Inventors Network. We try to meet once a quarter, but lately it's been meeting about once a year, and I actually sent my entire email list this meeting to let them know that this was something that they do. We have a website. It's called Arkansas, the whole state name spelled out, invents with an S.org. ArkansasInvents.org. Information about every meeting that we've had since 2006 is on there. If you do become a member, there's a lot of additional information that I send you that I've gathered over the years. Because getting a product to market is more than just the intellectual property for it. It's, how do I get a prototype? How do I show what I've made? Can I create one in my garage and sell it to some friends and family? Because I'm a big proponent. If you find somebody that's going to pull their wallet out and pay you for your idea, that goes a long way to make sure there's a market for your product and you can sell it. Then once I get my product made, how do I get it distributed? How do I get it on the store shelves of Walmart or Target or Kroger for that matter? So that's a whole different ball game. I really spend about 80% of my time marketing products. In today's age, getting a product made or getting it designed and getting it built, that's usually the easy part. It's getting it on the shelf at your local store. That's where it takes the time. So please, if you've got some additional questions about how to get your product out there, ArkansasInvents.org. We'd love to see you at our next meeting. At least give us an email so that I got your email address. The next time we hold a meeting, I'll make sure that information gets sent out and you get put on that distribution list. Thanks again, Tom.
Thank you. Appreciate it, Chad. Thank you. I've run a little bit over, but I do want to take some questions before if anybody had questions on the presentation, be glad to take. Yes, sir.
You mentioned the one that
Now, since there are people at the online that won't be able to hear you, we're going to have to pass this thing around.
you mentioned the 1 year grace period, and I've been through the patent process quite a few times. My understanding is that internationally that does not exist. Is that correct?
So the question is regarding the grace period. That is, if there is a public disclosure of something, the 1 year clock starts ticking. You're absolutely right, that only in the United States and just a few other countries, and that can be a real danger for someone who gives a presentation, because you may lose your international rights if you don't have a patent application on file before that. It can be a provisional patent application, but so I'm glad you pointed that out. Oh, you've got it. Thank you. Okay. Any other questions? In the salmon coach.
I'll do.
You do it? Okay. Well, until he gets the microphone.
Who had the question?
Jay.
Right here? Okay.
If you do the provisional patent, is that considered public?
So, well, thank you. We don't have any slides on this presentation that, we don't have any slides that show, that go into detail about provisional patent applications. But notice I said the term patent applications. There's no such thing as a provisional patent. A provisional patent application, which is optional, you don't have to do that, but it gets your foot in the door, and then you can follow up that provisional patent application in 1 year's time with a non-provisional patent application, which references that earlier patent application. In fact, I guess we didn't have as a handout. We normally have as a handout, but they have the handouts. They have the information on our USPTO website on the provisional patent applications. And I know they have copies here at the library. In fact, their whole book, there's there are two schools of thought on the value of having a provisional patent application. If it's like Chad mentioned, if it's something that you were in a hurry about, and you want to go ahead and get, perhaps you want to go ahead and get examined in a hurry, that's just going to that may slow down the process. On the other hand, oftentimes that provisional patent application, some of the value of it, not only in establishing the filing date, but it gives you additional time to perhaps fine-tune your idea or to take your idea around to companies to get them interested. You can file on more than one aspect of your invention, more than one provisional patent application, provided that you're following up within 1 year. One outstanding book on this topic is by Nolo Press. It's called Patent Pending in 24 Hours. The reason why it's called that is because you can file for a provisional patent application electronically. The book by David Pressman, Patent Yourself, spends some time talking about provisional patent applications as well. Again, it's something you might want to sit down and talk with your patent attorney about, because it is an optional approach, but it does give you some additional time to consider. So something to think about. So I'm glad you brought up the question about provisional patent applications. Just remember, in and of themselves, the other question you asked is whether or not it's made publicly available. No, it is not publicly made available then. It's not truly a publication. It is not even examined by the USPTO outside of a quick glance to make sure it meets all the minimum requirements. However, if at a later date you follow that up with a non-provisional patent application, and that non-provisional application file shows up in public payer, there will be, remember I said that public payer was the Patent Application Information Retrieval Database? There will be a section of that for that provisional patent application. If indeed it goes to that process where there is publication of the application, public payer. So you can actually look at them. It's a separate file in the whole file wrapper, but it's not in a searchable database for other people to see, which I think is what you're asking about. Okay. It sounds tricky, but it's not meant to be. It's not considered a publication at all. Question to that? Nothing to that.
Yes. Once you file your provisional patent and your 12 months start ticking, and you have an amendment or you have an additional idea to your original design, and you said you can file that also, does your 12 months start ticking again, or is that still the same?
I'm not an attorney, but as I understand what I do see in patents is that the the non-provisional that, application that you issue, they may have different priority dates based on the different claims, based on those different content, the claims that you're talking about. And in more complex patents, you see that. But if you're going to try that approach, talk to an attorney. Yes.
I have a true or false question. In regards to a utility design versus a design patent, I'm a designer and manufacturer, and I've often heard that all somebody has to do is change a whole location or something like that on one of my components that I design and manufacture, and it can qualify as a new patent.
My understanding is it's pretty easy to work around design patents, and that's part of the reason why they don't have as much. The length of protection is not as long as a utility patent application. We have available to you those green booklets that are on the table over there for those of you who are interested in possibly filing a design patent application. That's a guide to filing a design patent application. And the paper copies next to it is a guide to filing utility patent application, or waiting for the actual to come back from the printer for the guide to utility patent application. And as I said earlier, you may recall in my presentation, it is not outside the realm of possibility for a company to file both.
Right.
One, they're protecting functionality, and the other protecting the article of manufacture.
So as far as functionality goes in manufacturing, in a utility, then if they simply change a dimension from here to there, from a 1/4 inch to an 1/8 inch, I mean, are there ways around it like that? That's what I'm hearing, and I just don't know if that's true or not.
I'm no expert on design patent, so I don't want to give you advice on that.
That was utility, function,
You-
a function.
Oh, the functionality?
The functionality. If they just change,
Well-
if I have two mechanisms that come together and they change the dimension of it or slightly,
That goes to, remember I mentioned that utility patents cannot qualify if they're obvious variations, and that would be something that would be obvious, merely doing a minor change like that. Again, obvious to someone of ordinary skill in that area, an engineer in that area.
that makes sense.
I think we don't want to run too late. No, I know you still have a lot of questions, because, but let's defer those for right now. We have break materials out there. We'll come back in 15 minutes. We'll get started on patent searching, and save those questions. And also, Neil and I will be up here during the break, and we'll be back. Sometimes you don't want to speak in front of the whole group anyway with your questions, so feel free to come. Groups are very valuable, particularly if it's a chance for inventors to learn from the successes and say failures, that's not right, but the stories of the experiences of other inventors. Because, for example, when people come to libraries like this, sometimes they ask, "Do you recommend an attorney?" Of course, we cannot recommend one patent attorney over another, but you can talk to other inventors and find out their experiences. I do want you to be aware of these other resources that are available. On the internet, you can do a search for United Inventors Association, and this is not only a listing of all different types of inventors groups around the country. There's kind of an attempt to certify inventors groups, but also resources in question. There's resource materials that deal with, again, those practical type of questions that you have. And one of our colleagues here was telling us about Edison Nation, and Edison Nation is how would you describe it? You recently got a patent. Tell us about it.
Edison Nation is just a simple website that's really useful. You just submit your idea, and they will find the companies that they have companies out there that are looking for ideas, and will invest money to put that patent. Whether it's whatever stage you might be in, that they will they're looking for those companies are going to put their resources to bring it to market. Basically, it's a really good area.
And do they require any money up front?
You don't have to have any money up front, but you can subscribe to their website, which you get a little bit more benefits, and it's a small, it might be $15 a month or something, not anything big.
Edison Nation, the reason why I know about Edison Nation is because we put on an Independent Inventors annual conference at our USPTO headquarters, and the founder of that. So this is one of the legitimate. This is a legitimate company, and it's kind of aimed at a way that inventors around the country can share ideas. So I'm going to talk to you later about ways to avoid being scammed by companies. So please be aware this is not one of those type of companies. But I did want you to be aware of that. You have a question?
Is Destination, is it a non-profit organization?
Yes, I believe so. Yes, I believe so. And now I'd like to introduce Neil Masson. We were very fortunate last year. Neil has many years of experience, not only helping people in libraries. He was previously at Detroit Public Library, but he came to the U.S. Patent and Trademark Office on a fellowship, and then joined our public search facility, our famous public search room, which used to have miles and miles of paper.
Miles and
copies of
miles,
patent
yes,
patents.
absolutely.
But now it's totally all electronic, with the exception for the plant patents. And Neil has a great deal of experience in helping inventors, and he's going to tell us right now about a recommended way to do a preliminary patent. Neil?
I have the mic should be live, I hope. Okay, good. Well, first of all, before I even get started with that, I just want to share with Tom's appreciation for the Arkansas State Library, Mike Strickland, our librarian here, and Carolyn Ashcroft, the state librarian, for having us here. They do a great resource here for all of you. And then for all of the sponsors here as well, the Arkansas Small Business and Technology Development Center, and Arkansas Connect, which is helping us with the broadcast. And certainly I want to thank each one of you who have come here today and taking your time to learn something about patents and trademarks. That's a great benefit. And for those of you who are watching from elsewhere, thank you for taking your time as well, because that's very helpful. In fact, that Tom was mentioning that I used to work in the public search facility. One of the former searchers who used to work in there is now back in Arkansas. He came back about 10 years ago, and I told him about this, but he's up in Fayetteville, so if you're watching, welcome to the broadcast that way as well. So let me talk about a few things. In the packet that you have in the right-hand side, you have a couple parts that I'm going to be talking about in this presentation. One will be the 7-step U.S. patent search strategy. There's a guide to the PAT-FT and the APT quick reference guide. And as we get into our presentation, I will be talking both about an index classification. You have a paper copy of what that looks like, and then our manual of classification, which is a blue sheet on that as well. And then there is a copy of one of the patents that we're going to be seeing in a little bit here as well. So let me get started. We're going to talk about this. So the session topics we're talking about are patentability, prior art, and Tom's already mentioned a little bit about what prior art already is. Doing the preliminary U.S. patent search, U.S. patent classification. I'm going to tell you the advantages of that, and then what the patent search steps are and the benefits of thorough searching. So next slide. All right. Well, patentability. Patentability goes in the question of what is new, useful, and non-obvious. Tom's already brought that up a little bit, so I'm not going to belabor that point too much for you. But that's always accompanied by a written description disclosing how to make and use the invention that may be patented, so that someone who is skilled in the art with ordinary skill can reproduce it. Okay? And you want to, so knowing how, if that patent is new and non-obvious requires doing this preliminary search that we're going to be talking about. All right. So prior art, as Tom already mentioned, it can be patents, and it can be patent applications, but it can also be the foreign patents and published patent applications, but it can also be those journal articles, magazine articles, books, magazines, catalogs, trade catalogs. It can be a source of disclosure, websites, conference proceedings, all of those. All right. So the preliminary search, ideally is going to be a classification search, okay? And there's reasons for that. We're going to be discussing what some of those are momentarily. But it can be supplemented, and it should be supplemented by a keyword search, but you don't want to be dependent on the keyword search either for various reasons. Tom, next slide. All right, so what are the problems of keyword searching? All right, well, we have a title of a patent up here, up at the top, which is toy in process of use. Does it tell you what type of toy it is? Does it tell you anything about what the process of use is? That's a rather vague title, isn't it? All right? I don't know if this is some type of projectile like a Frisbee that I'm playing with, or if it's some other kind of toy that I might be using and manipulating with my hands. I have no idea. It's just a very vague title. We have obsolete terms and names as well. We have LP, we have hi-fi, we have a laser disc, water closets, all right? We have a mouse with it, which can be an animal, or we have the mouse, which is a peripheral computer device, all right? And then we have a rodent extermination device, all right? I'm going to, before advancing to another slide, I just want to advance a couple other thoughts to you as well. When I go home and I sit down to eat, I'm sitting at a table. When I go to work, I'm sitting at a desk or what could be a table. If I had a new invention for assembling the table or the way that the table looked, the last thing I would probably want to do is a keyword search on table. Okay? I would guarantee you would get thousands of hits. You would probably get hundreds of thousands of hits. But you would have table 1 and table 2 and table 3, and all you would have is tabular data that had nothing to do with this idea of what this is all about. We actually have, and I would use this as an example when I was showing in the public search facility, novice inventors about the problems of keywords. And I would take them into a classification schedule that would deal with tables and work surfaces and that. And the title of that happens to be Horizontally Supported Planar Surfaces. Okay? Now, to further illustrate that point, I would say that the supports for this planar surface that we're dealing with are probably secured by some type of a threaded fastening engaging device. Do you know what I've just described? I've described either a screw or a bolt, okay? So if I'm doing a search for a bolt or a screw, and I reject all these other patents, I may have missed the one that's saying a threaded fastening engaging device, or any other way that the inventor or the attorney for that applicant has chosen to describe the invention, all right? How many of you remember koosh balls from the 90s and so forth? The title of the koosh ball patent happens to be a generally spherical object using floppy filaments to promote shear capture. Now, as opposed to the title of toy in process of use, where we have a very vague title, now we have something that is very, very specific, and you can almost visualize what this one is all about. All right? So, next title. Okay. Other problems that we have are British equivalents. All right? If I'm searching for color, C-O-L-O-R, there might be some patents that are coming from Britain or Europe where the pronunciation is color. All right? There are also spelling errors of repellent versus repellent. We have acronyms and abbreviations. All of those become problems for searching in keywords. The number one criteria of problem of using just keywords, you cannot go beyond 1976. If you're, like Tom was saying, if you're using nanotechnology, 1976 will probably be just fine for you and previous and after that. But if you're using general mechanical areas, a lot of those technologies may go back a lot further than just 1976. Tom mentioned the example of a individual who came to Arkansas Library and did a search. Huh? Arizona. I'm sorry. I'm getting my A's mixed up. All right. Well, I happen to know of a situation where when I was in Detroit, and I used to go to an inventors club as well, and there was the person who is still a very good friend of mine. He's a patent attorney in Detroit. He mentioned of a friend back in the 70s who invented a new form of what he considered solar water heater. Now, this was back in the 70s. This individual did a patent search. They went back 50 years and they did not see a single solar water heater that came anywhere close to what they were doing. They filed a patent. They were in the prototyping industry where they created their own prototype for this, and they still spent thousands of dollars building this prototype. And the patent office came back and found a solar water heater that wasn't made out of plastic, but was made out of glass, dating from the 1840s. Okay? So again, it's this matter of, if the keywords don't take you back far enough, you always want to find the classification search and think about how far back that technology can actually go. Sir, you have a question back here.
So the relevancy of this thing about the time is the fact that it might become part of the public domain even prior to that?
Absolutely. If it's public domain, it's known art, and you cannot, so it takes care of that issue of novelty, and you cannot get a patent on it. Okay? All right? Otherwise, I'd go back and try to get Alexander Graham Bell's patent on the telephone or Thomas Edison when it would expire, but guess what? The line would be from here to Los Angeles trying to get back into the patent office to file for those same patents. So no, they're the public domain and they go against novelty. All right, so what is classification then? Well, classification is simply, and in the US patent classification, we have currently 450 classes that are subdivided into over 150,000 subclasses. So we get rather specific in where we're going. But fortunately, there are systems by which that I'm going to be talking about that help us get into this very deep classification system. And so in general, a classification system should be hierarchical in nature, organize the things by their characteristics and relationships, and it's useful in searching large collections of information. All right? Think of yourself at a grocery store. Grocery store is a perfect area of a classification system. You're going down the dairy aisle. You're going to find dairy products there, right? Well, within that aisle for the dairy products, you're going to find an area that is related to butter and margarine, another area that will be for yogurts, another area that will be for sour cream and cottage cheese, and then you're going to have your various types of milk. So those are subcategories within this classification system of an aisle for dairy products. And then you're going to have another aisle maybe for cereals, et cetera, et cetera. So you understand the system, all right? Well, same thing in the library. We have a Dewey Decimal System, and that's a classification system for technologies and books and that information that we're looking for. All right, so a preliminary search for patents. We're going to begin here. We have that 7-step search strategy that I mentioned here. And Tom, we're ready for the next slide. All right, so we're going to do an actual search here. And we've got this idea for our pet dog where in the winter months, the water dish for him doesn't freeze. So he has access to water all the time. So, okay, Tom? All right. So that first step in this 7-step search strategy is really the most important part for you as the inventor to deal with. What is the invention? What's the essential function of the invention? What's the end result? What is it made of? What is it used for? All right? Well, in the case that we just described, what it does is a bowl that holds and heats water for dogs. All right? The end result is to keep the liquid from freezing, so the dog has access, and our pet has access to a supply of water outside. What is it made of? Well, it could be aluminum, it could be stainless steel, it could be electric heating element or using an electric cord. And what is it used for? Well, it's used to either for water or liquids or soft food or anything else that might freeze. And it can be used not only for dogs, but for any other type of pet animals, okay? All right, so now we want to start considering what those synonyms are that might describe this. Where else could this now reside in the patent literature? We just kind of gave an overall view of what the patent or our invention is all about. So now we want to come up with synonyms. Okay, so we have dog, cat, pet, bird, animal. All of those would be part of the synonyms. Bowl, dish, receptacle, cylinder, warm, heat, melt. You see what the words are there. So, okay? So the first thing that we want to do then is take those synonyms that we have developed and use that in our index, which is this green sheet here, and find where in that index the classes and subclasses would exist in order to find out where this invention is going to be. We're looking at things that describe the function and the composition of the patent. We're noticing the class and the subclass for each one. And in some of these cases here, you're going to notice that there's a plus sign in this index. All right. When I was in the public search facility, I would have people start with the index. And I would tell them that you want to, go from the index to the manual of classification and find out where it is. And many of them would come back with a class and a subclass for me with a little plus sign, and then I always knew that they hadn't gone yet to the manual of classification. And because all the plus sign is indicating is that there are maybe further subclasses underneath that initial subclass that also bear on the same technology. So let's take a look at what some of these are. Well, when you go to our website in classification, you come up first with this page here, and then off on the bottom you see where it says Index the U.S. Patent Classification System. All right? And we're just broadening that out a little bit. Well, we're going to go and we're going to search under A for animal. All right? So, Tom, next slide. And we get up to animal, and we see one for watering devices. And that shows us that it's in class 119, subclass 72 plus. Now, the 72 plus, the plus sign is only indicating that 72 is the beginning subclass, and then probably are additional subclasses underneath that we want to look at. All right? And then the other thing that we want to do is also under D, we have dish and we have heater. So now we've gone under the D area, and we find a class 126, subclass 246. So we got two areas of key areas that we want to be searching in. All right? Well, we're probably going to zero in on this 119.72 plus in the example we're doing. But if we're actually conducting the search, we're also going to go over here to 126, 246, and all the other possible classes and subclasses that we found as well. All right. So, next slide. All right. So, we are in step 3 now. We've gone from the index, and we're going over to our manual of classification. And you notice that the class title is Animal Husbandry. And
isn't this one of your handouts? Isn't this from one of your handouts?
This is also in the handout. This is on page 72. This is not 72. This is the blue sheet, and I believe actually on page 5, you will find where on this index, in the manual classification, this actually resides on, within the index, if you're looking in the manual classification. One thing I'd like to point out to you while you're looking at that blue sheet, notice the number ranges, okay? I am going from, well, let's start at the very beginning. All right, on the first page, we start out with subclass 200. We then go up on the second column, and once we get up to 270, our next subclass is 6.5, et cetera, et cetera. The numbers are not in sequential number. Well, what's going on here? What's going on is that these schedules, they change as the technology changes. When Class 119 was first published, I guarantee you that all the numbers of all the subclasses were in numerical order. As the technology changed, and we needed to have further breakdowns of some of those subclasses, and new technologies emerged that we needed to put in, we placed those in where they belonged in the hierarchy, and rather than renumbering all the subclasses all over again, we just inserted the new numbers where they logically fell, okay? So don't think of these subclass numbers as something that's in numerical order. Just think of them as an address. That's the best way to look at them. And then, so the other thing is that if the index is leading you into, like we have subclass 72, and you're looking at the beginning of the subclass or the class schedule as starting out with 200, you just have to dig through that manual classification to find out where 72 actually resides. All right, so we're looking at the similarities. Tom, you want to hit the next? All right. A good way of looking and understanding a class schedule is think of an outline, okay? In an outline for a paper that we're doing for school or whatever purpose we might be doing, we're going to have the title of what it's all about. So in our case, animal husbandry is the title of our term paper, okay? Now, also in an outline, we have our Roman numerals, which are our main topics, okay? So we've got Roman numeral 1, Roman numeral 2, Roman numeral 3. Well, the Roman numerals on this, our US classification system, are those that are in bold and all uppercase. So subclass 69.5, which is bird bath, and subclass 72, which is watering or liquid feed device, each one of those would be considered like that Roman numeral in an outline form. And then underneath that, you see a number of subclasses that have indents to them. The one dot indent would be, again, using the example of a term paper outline. Underneath the Roman numerals, you have the A, the B, the C, in uppercase lettering. Well, those are what the one dots are. And the two dots would be the further indentation underneath the large letter A's of the smaller letters, et cetera, and the numbers below that. All right? So, as we're looking at this particular class and subclass schedule, we started out with 72, but it was 72 plus. But notice that 73 winds up being temperature controlling. That subclass better fits in with what we are working with for a heating element for a water dish than does subclass 72. So we're actually going to use subclass 73. So our class subclass is going to be 11973 to search for this watering dish. All right? Now, the next thing to do after going into this manual of classification is also to look at the definitions. And there are definitions that go with each one of these. All right? The definitions can be very, very useful because the definitions wind up being considered a map into this large US classification system of 450 classes with 150,000 subclasses. All right. Well, what winds up happening is that you think that you found the right area in the manual classification, but the definitions start guiding you into other areas where this discussion may actually wind up being. So Tom, you want to go to the next slide? All right, so if we click on the number 73 there, our subclass, that is going to take us immediately into our definitions. And if you take a look at this, we have the definition for subclass 73 as this subclass is indented under subclass 72, so we immediately know that 73 is integral to subclass 72, which is above it. And it's for holding, water holding devices for supplying stock involving a trough or a combination of a barometric fountain or other means of constant supply with a means to prevent the freezing of water or to regulate the temperature for other purposes. But let's take a look at below that. We have C, or search class, and we have one which is 106, compositions, coating, or plastic, and then it gives us the subclass numbers underneath that for compositions useful for insulating purposes. Well, if this watering dish that we were thinking about for this pet animal wound up, instead of using electrical heating element or something like that, if it just used some form of insulation that kept the water dish above freezing temperatures, guess what the definitions have just done for us? They've pointed us into the more proper class and subclass where we're going to find the patterns that better represent the area of a watering dish that uses insulation. Okay? All right. So, the other thing is, why is the searcher also referred to class 126? I didn't go into that one definition before that went into 120, but 126 is right here. I used the 106 instead, but all right. So go into the 126. All right. Stoves and furnaces. I'm looking for a water dish. I'm not looking for a stove or furnace. But let's take a look at the proximate function. That's the way that we classify and look at technology at the Patent Office. Similar processes or structures that achieve similar results are considered to have the same fundamental utility. Well, here is the patent over here that falls under class 126, or one of them. Take a look at that. We have a heating element, and we have like a large tub, but could you see this like over at a farm with animals where you have water for the stock animals to come in and drink out of that? I could. All right? So it's the same benefit. So again, you want to be aware of what some of these other classes are that bear on that. Let me follow this example up just a little bit. I brought up the koosh ball before. Remember? The koosh ball is actually in class, I believe it's 276, I believe is the class, which is entitled Amusement Devices Projectiles. Makes perfect sense. You throw a koosh ball, right? In the koosh ball patent, there are cross-references to a class, and there are actually patents that are cited in that koosh ball patent, which go to class 15. Class 15, I'm going to tell you what the title of that one is, and I want somebody to tell me where the relationship is. Class 15 is general cleaning, scrubbing, brushing, cleaning, and general scrubbing. Okay? So what is the examiner thinking about with this koosh ball that has these floppy filaments that relates to class 15, which is general cleaning and scrubbing? Anybody have an idea? Huh? Material, okay. How many of the women in here use like a sponge or a netting for bathing? Okay? And that's, so you can see that structurally it has some of the same bearing to this koosh ball, but with something that is far more absorbent of water and soap than what a koosh ball would be. But you see that structural relationship. Okay? All right. Step 5. We've gone into the manual classification. We've checked the definitions. We are now sure of what class and subclass we actually want to search based on what we've learned from the manual classification and the definitions. So now we actually want to go in and do the search in the PAT-FT and the APP-FT databases. Okay? So Tom, next one. All right. So from the PAT-FT, we have searchable fields here. And this goes from 1790 through 1975, which are searchable only by the issue date, by the patent number, and the U.S. classification. All right?
They have a handout on this. They have a handout on this.
Yes, and you do have a handout on that as well. All right, and that is right there, okay? All right, and you also have the AppFT searchable databases as well. All right, well, when we go in and, when we've gone into and did the search in the manual classification, what we found, and when we went over to 73, we found over on the far left-hand side, we have a letter P and we have a letter A, which kind of looks like a rocket ship. And by the P and the A simply stand for the PAT-FT database and the AppFT database, okay? And by clicking on the letter P, we will automatically launch a classification search on class 19, subclass 73 in the PAT-FT database, all right? And by clicking on the A, you'd go into the AppFT as well. And these are the patents that came up. There was 309 when this slide was done. It starts off with the design patent, but we also have patent 7,735,000 and a heated poultry fountain, et cetera, et cetera. These are the patents that you can now begin searching on, all right? And you can click on each one of those, and the same thing with the results for the AppFT. And you'll notice what the difference is between the published application and the actual patents themselves. Can you go back one time? Okay, by looking at these though, what was the other thing I wanted to mention? I lost my track there for a second, but that's okay. Go ahead, we'll go ahead. I'll think of it.
What do you want to talk about? Maybe since titles can be sometimes be ambiguous, can you go by titles?
Oh, well, no, you can't. You don't want to go by titles. That's because remember this toy or process of use? Remember that was a rather vague title? I don't know what that means, so I need to really look at it, okay? By excluding patents to look at just simply by the title can be really dangerous. You really want to look at it and get an idea by examining the patent what is actually going to be there. Because if you exclude, you're running into some real danger that way. All right. Now this is the copy of the patent that you actually have a copy of here as well. I just want to go through a little bit and show you the parts of this patent. We have a title of the patent. How many can see what the title of the patent is?
Can you read the number for the people at home?
Oh, absolutely, because if you can't see it from home, thank you, Tom. It's U.S. Patent 6,915,761. All right? So that's the patent number right there. And then we have the title, which is a waterproof pet feeder. And we have an abstract, which is off on the left-hand side. And then we also have the representative drawings and those, which is all on the front page of the patent. I will mention the other thing that's on this front page of the patent for those of you who are looking at it on, you see some numbers that are in parentheses. Those numbers that are in parentheses are actually called INID codes. Those are these numbers right up here. Those INID codes really mean, INID is an abbreviation for Internationally Agreed Numeric Numbering System, okay? And it is used so that if I am looking at a Japanese patent and I see the number 54, I can't read Japanese, but I can tell you that whatever I'm seeing on line 54 is the title of the patent. When I look at number 10, I know I'm looking at the patent number and not an application number. So those things can help me when I'm looking at international patents as well. All right? Next slide, Tom. All right, so we got the waterproof pet feeder, abstract, and the representative drawing, and then the next page should be our drawing sheets. Now, we'll have drawing sheets as well, which are follow after the front page. The drawing sheets may go up to 10, 15 pages. There can be many, many drawings for a patent depending on how specific it is. And then we have the specification of the patent, which provides, in the specification of the patent, we're going to have areas of the background of the invention. We're going to have an area of the detailed description of the invention. The summary background of the invention, especially the background of the invention, gives you what the past history of this technology was. Okay? So what the inventor is trying to do is say, okay, this is what the problem has been. This is what has been done kind of like in the past. And then when he goes to the summary of his invention, he's starting to describe how he is improving on the already existing technology that's out there. And then he's providing a detailed description of the invention, which also includes information about the drawings that he has submitted as well. Okay? And then the final area is the claimed subject matter. When you get to the end of the specification, you're always going to have a statement of what is claimed, or I claim, or we claim, or what we claim is, something like that. Those become the boundaries. Those become the fence posts of this intellectual property. All of the others, the drawings and the specification part, act as a background and a supporting area for the claims, but the claims actually say what the inventor is claiming and what the office, the patent office, is agreeing with the inventor that says, yes, you have exclusive rights to be able to exclude others from manufacturing, making, distributing what is stated in the claims. Okay? All right. So the next thing that we really want to do, if we find a patent that is useful, if this particular patent here is useful to us in what we're doing, notice that it will have references that are cited, and those are right here, okay? What are the chances, if this particular patent is relevant to what I'm looking at, that I want to also look at those references that this particular inventor or the examiner who examined this particular application, I want to take a look at those as well, because they may guide me further into revealing something that might bear on the invention that I'm trying to find, okay? So we can click on each one of those hyperlinks that are there, and Tom, the next one. And then you see what those, and then so we can look at each one of those patents individually with a hyperlink there, all right?
And these are the forward citations.
Oh, these are the forward sites? Okay, these are the forward, all right.
Reference by.
Okay, I was hoping, yeah, because you see where it says referenced by? If you have a patent, let's say you have a patent that you're looking at that's, maybe dated the year 2000. All right, well, there could have been patents that have been issued since then that have cited that. And so you can do what is known, that would be considered a forward site. So you want to find out who has also cited this individual and who's improved upon that. So this process that we begin with doing a patent search is not just bringing up the patents that are already there, but once we find those patents, they lead us further into other areas that we want to extrapolate on and find out other areas that are going to be useful to us.
Question?
Mm-hmm. Yes?
Can you just, I don't know if now is the time or not, but can you just summarize how this process would be the same or different for like a business process as opposed to a design?
Are you talking like with business method patents or?
Yes.
The same thing applies. Absolutely the same thing applies. What you need to do with those is find out where it's going to be classified in the classification system, and begin looking at those patents as well. And then, looking at the literature as well. We talked about all the prior art would be, and so you want to look at those things as well that you can. Yeah, Tom?
Give me the microphone.
Microphone?
It's on the seat.
Ah. Is it on the bottom?
It's working out. That's a very good question, and that is, how do we apply this to other types of patents? Remember when we gave the presentation earlier when we were talking about patents regarding requirements, novelty, and non-obvious? So if it's a business method, if you're looking at a business method patent, and if it cites other earlier related patents, if it's one that's close to yours, or a software patent, I had a question earlier today about a software patent, then during this process, you want to make sure that your invention is novel, and it's not obvious to one of ordinary skill in the art. So this is the part of the search process is to find related art, and to make sure it's not the same as your idea. And so, doesn't matter if it's a dog dish, or we have another example with a burglar alarm, auto burglar alarm, a mechanical patent, or chemistry patent, or business method patent. Ultimately, what we're looking for is, we found this one patent that's very close to ours, and we're using the power of the citations in that patent to see if there's something out there that it's citing that might be the same as ours. Because if it is the same as our idea, we can't get a patent on it because it's not novel. Or if it by virtue of the fact that it's already been out there, it would be obvious to someone of skill in that area. So that's kind of give you a sense of, yes, we have more questions.
So you use a citation to say, this is what exists now, and this is what the change is that my idea implements to make it new and novel. That's why the citation process is important.
And it works two ways. As Neil's going to show you right up here with this field of search, look at that screen up there for step number 7. This is information that comes from the front page of the patent. The field of search is not what the applicant searched, it's what the patent examiner searched. So you get a real sense of this whole process that the patent examiner, USPTO, used. And ultimately, after searching all of those classes and subclasses, he or she narrowed it down to those 9 classes and subclasses for this particular invention. They're based on the claims, what the claims are in that patent. So again, this is our key. Neil referred to this as kind of a map, where we're kind of like detective work. We're trying our best to see if there's something out there that is similar to our idea. If we find a relevant patent, then we're going to dig deeper. And we can use these clues that are on the front page of the patent to expand our search. Neil showed you through the indexed U.S. patent classification, that got your foot in the door as far as a right class and subclass. And now using these other techniques, we can expand our search to possibly find other related prior art. Remember, all I said is it takes one patent out, one disclosure in a patent or in a non-patent publication, but one disclosure of that invention previously that would prevent you from possibly getting a patent on your invention. Remember, someone was asking me earlier in the audience, they said, well, you know, I've never seen this out in the commerce. Maybe I could get a patent on it. Well, just because one hasn't seen it in commerce, there are many great ideas that have gotten patents on them, but they've never been able to get they've never been able to successfully exploit it commercially. So this, about the 8 billion U.S. patents, a very, very large number of them were great ideas that just never made it out in the marketplace. But that doesn't matter whether or not it got out in the commercial world. The question is whether or not it was ever publicly disclosed. And it's publicly disclosed in a U.S. patent or a U.S. published patent application. Is there a question, Rachel?
Yes. There's kind of 2 parts. Number one, it looks to me like where we're still trying to protect our claim themselves, not necessarily the patent, but the claim, the individual claims in the patent is what we're really looking to seek protection from, correct? 4.
That's the primary focus.
Right, that's the primary focus. And then number 1, I'm not sure if everyone else gets this picture. I get the picture of this evil patent, person who's saying, no, we can't give you this patent. We're going to find every reason not to give you this patent. Obviously, that's not their job. The job of the patent officer is to help the inventor find ways to get patents. So can you speak on that so that no one walks around here with fear that they're going to be turned down?
Well, you might be turned down. I can't promise you that. And what's the approval process of patents is roughly about 50 to 60% of patent applications are
I
approved.
believe it's, yeah,
So those are pretty good odds. I think when you consider the huge number of applications that come in. If you are filing pro se, that is, if you do not have an attorney representing you, and this is made known to the patent examiner, the patent examiner will try to do what they can do to, in a very basic level, to try to help you in the writing of the claim. They're not going to give you necessarily you're not going to have the advice that you're going to get from an attorney necessarily, all the tricks of the trade, but if you are not being represented, they will do what they can to make sure that you have the basic wording is appropriate. So yes, we're not out there we probably are emphasizing a little bit too much of the negative, so I'm glad you pointed that out. And one more question, and then we'll get back to me.
We sort of determined that the key to finding out whether or not you have a patentable proposition is finding the right class and subclass of your invention?
absolutely.
But as you see in that invention up there, there's more than one class and subclass there based on the claims. So it's not just it's not one perfect key to fit a lot. Based on the way the patent is written, there may be more than one class or subclass. The thing that we're looking for, though, is we want to see if your invention has previously been disclosed in another patent. And this is a way of finding it without relying just on keywords. It doesn't mean you can't supplement your search with keywords, but this is part of this process.
Absolutely.
Neil?
And, like Tom was mentioning, take a look at the current U.S. class is the current U.S. classification for the particular patent that you are now looking at, okay? And on this particular one, we wind up seeing that there are 4 different main classes. There's class 219, there's class 119, class 338, and class 392. I don't know what the titles of each one of those are, but again, this particular patent wound up going into 3 broad classes and several, and about 7, 8 subclasses as well, okay? Notice that the first one is 219, and then we dropped over to 119. All that means is that when this patent application came in, the main bulk of this particular patent right here that we're looking at probably, or for this one, is resided in class 219. So while we wound up searching in class 119, the main focus where it was being conducted and where the examination was taking place was probably in class 219. That was the examiners who were looking at it. So that first class and subclass is basically telling you where it resided for the examination purposes. But for your purposes, each one of those classes and subclasses may be important for determining where that particular patent is also classified. And so if this one is similar, you may want to look and find out what those other classes and subclasses entail. I just want one more thing on that field of search. The field of search is telling you where else this particular examiner wound up searching. These are the areas where he conducted his search. Maybe he didn't wind up classifying in these particular classes and subclasses, but you can use his expertise by going into those other areas of field of search. All right? One other thing that I wanted to bring up, and that's when I had that, when we were looking at the classes and subclasses. We have gone through, and we've gone through the index. We've gone through the manual classification. We've gone through the definitions. We get to the definitions, and we're really sure that this, and confident, this is a class and subclass that we want to look for. But guess where the proof of the pudding winds up residing? It resides in the patents that we're actually looking at when we're looking at this particular class and subclass. So we're going, well, wait a second, this isn't really hitting on what I thought it was going to be about. So hopefully then when you're looking at that particular class and subclass, maybe there's 100 patents in this particular class and subclass. And out of the 100 that you are looking at, maybe 1 or 2 of them get a little bit closer to where you really want to be, find out what other classes and subclasses that particular patent is classified in, and maybe that will link you back into a more proper class and subclass to begin doing that search on, okay? So remember, the proof of the pudding is always resides in the patents that we're actually looking at, all right? All right, so again, what is our search strategy? Brainstorm the keywords that describe the invention. That, for me, is the most important thing that you can do before coming and conducting your search. Because if you haven't done number 1 properly and number 2 properly, you're never going to be in the proper area that you want to be in. Maybe you're going to get some general ideas from what you're looking at, but those are essentially the key ones that you want to be working on. Then number 3, go to the index and find the index where you want to use in number 2, and then number 3, go actually to the manual of classification, find out what other indented subclasses reside underneath there that might be a better fit for you. Confirm that then with the classification definitions, and then conduct the actual search in the PAD-FT and the AppFT. Notice the one thing that I'm saying is that you have to conduct the search in PAD-FT and AppFT. You want to do both, okay? Later on this afternoon, I'm going to be talking about the PubWest database that's available here as well, and I'll be showing you some advantages that PubWest can do for you that PAD-FT and AppFT cannot do. All right? Then review the claims, the specifications, the drawings of the documents, and look at the references cited, and also do a forward search. Tom, you have another point?
And one thing we want to make clear, all of these steps are electronic. They're all done on the USPTO website. So it's using terminology like manual classification. That's only because it used to be an actual physical manual. But these are all available on our USPTO website. The index, manual classification definitions.
Absolutely.
At one time it was a very tedious process to do this physically, and now it's all step by step can be done electronically.
Mm-hmm. Just adding to that, I can tell you, I'll tell a quick story later after we finish this one. But all right, so what happens if you can't find the appropriate class application? You've gone through the index, you can't find the right keyword. You've gone through the manual and you're just lost right now and you can't get really started. All right, well, use a keyword search. But realize in this keyword search that you're doing that the words that you're using may not be the only words to describe the invention, and the words that you're using may be bringing up patents that don't even relate to what you're looking for. So that when you do find a patent that does relate to what you're looking for, then jot down the class and subclass, and then find that class and subclass, and then run from there and take and go from the classification system. And always ask for the PTOC librarian for a classification suggestion form. We have a suggestion form here that your libraries have. We distribute them to all the libraries, that if you're really, really stuck and you really can't find something, you can send one of these classification forms into the patent office. It goes into a public search facility where I used to work. And one of the staff down there will look at it and try to find out where field of search would be best for that, and they will send that form back to you so that you can come back to the library or even from home and do your search that way online. Okay? And don't exclude keyword searches, okay? Yeah, you can still do them. You know, the classification search that we're talking about is the best way, absolutely, of doing this search. But a keyword search also might pull up some things that you didn't realize, and they might lead you into some other classification areas that you hadn't realized. So a keyword search is still always useful. There is truncation that you can use as well. So, you know, with car and dollar sign, I wouldn't say you want to use really car and dollar sign. That's a pretty poor one, because not only are you going to get car and cars, you're going to get carbon and carbonation and things like that. So it's not the best example, but it's an example to use. And then we have the image viewer as well for quotes and putting terms together. All right? Document the search. Absolutely very important, very, very critical. you know, when you document your ideas, you have a process that you know kind of where you've been through this process, and you can take that then, if you're doing the search yourself, you can take that, if you're going to go with a patent attorney or a patent agent to help you write the application, you can show him where you've been. You can show him what classes and subclasses you've already been searching, and that will help you a lot. All right? All right. Again, you will avoid the application with claims already described in the prior art. If it's claimed, you can't claim the same information all over again, so you want to stay away from that. So it helps you with that. And becoming better prepared to, again, discuss your ideas with your patent attorney. All right? All right. And don't forget that the images are in TIFF, okay? We also have a tutorial online. You can go to our website. There is a tutorial. And much of what the examples that I just gave and the steps that I just showed you are outlined in this tutorial that's online as well. All right. You also have the PTO, the staff here at Arkansas State Library. You have our website, www.uspto.gov. Our contact center at PTO. The Inventors Assistance Center at USPTO is also very useful. And then the Electronic Business Center for additional help that way. So
we'll get back on track here. So we'll take a few questions. And then we will break for lunch. When we come back from lunch, I will go over how to avoid getting scammed by niche promotion firms. A few questions. We'll take just a few questions right now on Neil's presentation.
Yeah, I'm just curious, what is the traditional length of time that, between the time a person submits an application and the time an examiner gets it back to them with the certificate?
Well, what is the traditional period of time? It's all going to depend on the art area. In areas that we are getting, hot areas that we are getting inundated by patent applications, it's going to take longer. Even though we try to hire patent examiners in these areas to help support those areas, if on the one hand you introduce a new gardening tool, there are not a lot of new patents coming out of the gardening tools. It may not take as long. The gentleman who was here a few minutes ago is working with us in AV. It only took him a year. But on the other hand, the average time is about 3 years now, and that's just an average time. So that's
You don't necessarily have to wait for a patent issue before you're able to try to move forward with it.
absolutely not. You can, again, things are a matter of strategy, but you wouldn't want to lose the opportunity to get your product out in the marketplace to wait on the patent office. Because, like I said, it can take on quite a while, so that's a good point.
you do have patent pending and, right?
You can get a sense of how long it's taking in particular art areas, in particular technology areas, actually by going to our weekly, what's now an online publication called the Official Gazette, because in the back of it, they have the different technology centers, and you get a sense of
You get a sense of
how
what
many months.
it's taken for first office action and to get a patent.
Any other questions about that?
So using the sponge and the douche ball example, what type of restrictions are there on, so like if I'm in the douche ball, it uses the exact same material as that sponge, is there anything where I would have to pay royalties on the invention of the material?
Well, what is claimed in the patent is what you're concerned about. It's not the material. Unless the material is something that was
name is Michael Strickland. I'm with the Arkansas State Library here. I'm manager of information services, and we're excited that you're here. We appreciate you coming back after lunch and joining with us. Tom and Neil are going to continue with some of the ideas that they've talked about and talk about some new things this afternoon. Also, I want to invite you tomorrow to either watch by live stream or you can register for Ms. Gongola's presentation. It's primarily geared more towards attorneys, but she will be talking about the new patent laws, American Invent Act. So just to make you aware of that. And as I say, it will be live stream courtesy of Connect Arkansas, who are here today. And they are showing this live. We've actually had people watching on this, so you're part of an event that's going out across the state. And we will be archiving this as well. So if there's something you forget or you want to go back over something, they assure me that tonight they will have it archived and it will be available. It'll come out in two parts. Part one will be the morning session. Part two will be the session that we have this afternoon. I just very briefly want to let you know that we here at the Arkansas State Library are also the only patent trademark resource center within the state of Arkansas. And if you have any questions or if you need assistance with how to do a search, if you need information about how to contact the USPTO or just want someone to bounce off of, we cannot give you legal advice, as Tom and Neil pointed out, but we're here to assist you in the endeavors that you have on getting inventions or trademarks. We have been a patent trademark resource center since about 1983. And so we do have some older resources. We also have links to the internet, and we have some public computers. I also, myself and a staff of reference librarians are here to serve you. We would encourage you to make an appointment with us, and we would be happy to sit down with you and work through the process with you. So just give us a call up here at the Arkansas State Library. We do have a website. If you just Google it, Arkansas State Library, you should come to our webpage. We are going to be hopefully developing some more patent and trademark resources soon and provide that information as well for you. Also, if you have suggestions on some ideas of things that you would like for us to maybe have webinars on or have someone from the USPTO or patent attorneys or whatever, please let me know. We would try to arrange that and make it possible for you to get more information. So we want to serve you, and we're just glad that you're here. So I'm going to turn this, yes. Any library that has internet access is going to have access to the USPTO website. Now, as Neil's going to talk about later, there is a database called PubWest that gets into a little more detailed kind of searching. And there's not that you can't search it on the public internet site, but it refines it more. So he's going to talk about that later. But sometimes, too, what we've discovered with a lot of independent inventors is they think that they are doing a really great job of searching. Sometimes they'll Google search and think they found everything. And as they've pointed out, it gets to be a bit complicated. There's old terminology. There's a lot of classes. There's a lot of subclasses. To be honest, a good patent search takes a long time. And most people, when they start doing the patent process, don't realize that. They think it's going to be a short, quick, I spend this in dollars, I spend them 2 days, and I'm done. I'm ready to patent. And unfortunately, it doesn't work like that.
Is your email address part of the packet?
My email address, I'm not sure if it's in the packet or not. Let me give it to you. It's a really simple email address. And I have cards, by the way, too. I'll be happy to give you my card. My email address is michaels@library.arkansas.gov. That's michaels@library.arkansas.gov. And let me give you the main phone number as well. Our main phone number here is 501-682-2053. Just call that number. That's 501-682-2053. And either myself or one of our reference staff will be happy to answer any questions and help you with the patent Any other questions? Again, thank you so much for coming today, and we hope that you get a lot out of this.
Thank you. Appreciate it. Thank you, Michael. Well, as a speaker, there's nothing more encouraging to see people come back after lunch. So thank you. Before we get started, let me give you a sense of what we're going to be involved with for the rest of the afternoon. It's not real long. I will go over how to look out to avoid getting scammed by invention promotion firms. And then we're going to show a video, a 20-minute video, to give you a real sense of how things work at the U.S. Patent and Trademark Office at our headquarters. And then I will go over just as we had a particular multi-step strategy for how to do a great job of doing a patent search. Likewise, I'll go over a multi-step strategy of doing a thorough job of doing a trademark search. One thing I did forget to mention this morning when I was talking about fees, it was included as an insert with your that blue booklet, the general information concerning the, what is it called? The general information concerning patents. But there was a new fee that was instituted on November the 15th, and that is, it's almost like a surcharge. It's an additional fee of $400 if you are not filing by electronic means, and that's half that for small entities, $200. That money does not go to the USPTO, it goes directly into the Treasury. It's an incentive to get people to file electronically. I do have to say, though, that on the trademark side, over 90% of the filings are electronic, and on the patent side, it's getting close to that. So it's not saying that you can't file by paper, but it's certainly trying to nudge people in that direction. And in the long run, it's really better for you, as well as it is good for the U.S. Patent and Trademark Office, that it's done electronically, because things don't get lost. And you get that immediate feedback in knowing that we received your application. So let's switch gears here for a second. I am a librarian. Prior to joining the U.S. Patent and Trademark Office in 2001, I was an engineering librarian at Arizona State University for 5 years. One of the most unfortunate things about being a patent librarian and helping people do patent searches is when they come into the library and they tell you that they have been scammed by invention promotion firms. I've literally had people tell me that they have lost their life savings to these companies. Invention promotion firms have been around a long time. You can look at old histories of the Patent Office, and there was the equivalent of this 100 years ago, but it's even more pervasive nowadays with the internet and with infomercials and radio commercials and that sort of thing. So what do you do as an inventor hoping to find success with your invention? How can you determine whether or not somebody's legitimate? Well, it's been a concern of the U.S. Patent and Trademark Office for many years. We don't like to see this happen to people. They're not associated at all with the U.S. Patent and Trademark Office, and in many cases, they have misrepresented themselves, having names similar to the USPTO. Back in 1999, Congress passed the American Inventors Protection Act, and part of that was an opportunity to address some of this. One of the things that you will find about the U.S. Patent and Trademark Office is we are not an enforcing agency on these sorts of things. But what we can do is act as a clearinghouse for information on these. So that's what the presentation you have in front of you, this one, Invention Promotion Firms, How to Ask the Right Questions. This is not a presentation that I came up with. This is a presentation that John Calvert, who's over our Independent Inventors Program, and our former Solicitor General put together, and asked that when we go out on the road and we give presentations like this, we cover. I'm not going to read every single slide to you. I know it's very boring when somebody gets up in front of a group and reads everything. The details are there, but I will kind of cover this generally, and for those of you who are particularly interested in this topic, I would suggest that you read it in detail, and that also the resources that I list at the end you consider going to. Now, Neil, if you go to the next slide, with the look and see if at the background of there must be a window that's open up in back of the PowerPoint presentation. No, that's the very end of the presentation. Yeah, so you must have hit the. Just go to home, maybe, or click on slide view and then go to first slide. I don't know.
Next on your list.
It is next on my list? Okay, we'll see what happens after that. There we go. I'm sorry. That was my mistake. I know at one time we had that, the last slide. That image is of a handout that we make available to PTRCs such as this, and we can send to you. But a lot of that information is included in this presentation. As part of the Inventors Protection Act of 1999, there are 10 questions that you can ask these companies. Ask it in writing, and they are required by law to answer those questions. So as you flip through these, you see the types of things. You know, how many customers have gotten a positive evaluation? How many customers have they actually contracted with next? How many people have actually made a financial profit as a result of getting the services of your company? How many customers have actually gotten licensing agreements for their inventions? Does your company go by other names? One of the things that we have found is these companies quickly change their names if they get a bad reputation, but it's the same company. Does it require an upfront fee? Companies should never be requiring an upfront fee to help you with these sorts of things. What is the total cost involved with that company's services? Next. Has that company ever been investigated by, let's say, State Attorney General's offices, the Better Business Bureau, Federal Trade Commission, that sort of thing? And who, if they have to use an attorney, who actually selects and pays for that attorney? Do they have, and you can ask to find out that relationship. Next. And ask them to provide, and this is of course good business advice, you know, any type of company, ask for references. They have to provide you with the names of 5 customers in your general geographic area. Do they provide a written opinion of marketability or potential success? And don't do this by email. Do this in writing. Get the answers in writing. They're required to answer these. They can't get out of this. So how do they work? They get you excited. They say, they will always say you have a terrific marketable idea. And they'll get you hooked with that. They'll tell you that they'll get you a patent. Well, nobody can get you a patent. And they will locate companies that will be interested in your invention. But what you as the inventor find out that if they are successful in getting a patent application through, they have taken the easy way out if they've done so, and it's probably a very poor quality, or it may be a case of getting you a design patent when what you really needed was a utility patent, or maybe all they've done is applied for a provisional patent application, which, as you may recall from this morning, you have to follow up in 1 year with a non-provisional patent application. You find out what you have is virtually worthless. So these slides cover the strategies involved. And these will look very professional, by the way. There'll be initial fees, $700 to $1,000, but it's going to get much worse after they get you really excited about it. They will always say you have a great idea. And once they get you to sign the agreement they get you to sign is then going to oblige you to pay much more money. Now remember, you know, when you're thinking about this, think if you use a registered patent attorney, a legitimate registered patent attorney. Those costs are going to be, at least initially, lower than some of these costs. Now, depending on the complexity of a patent application, it would get a lot higher. They're going to have a patent attorney that they have a sweetheart agreement with who is working solely to help that company, not putting your interest ahead. Well, as I said, they may not apply for a utility patent application. They may look for a way of getting around that, but just so they can say, oh, they applied for something for you. They'll say, oh, you have patent pending status. But what did we say earlier this morning? Patent pending status merely means a patent application has been on file with the USPTO, nothing more than that. They will come up with something that has minimal, the claims will have no real value in your application. Well, at some point, they will, once they've done that minimal work to satisfy you that they've started something, then they're not going to typically go any further with it. That application is going to go abandoned. You, at some point, are going to realize something's up, and it's going to be too late to do anything about it. Their patent attorney that they have on file literally may have several hundred patent applications that would be abandoned. If a patent does issue, it typically will have no meaningful patent protection. And by this point, you realize you've been scammed, but it's too late. Suddenly, they don't answer your phone calls or your email messages. Well, what are your options? Do you have to just give up? Well, there are some options available to you if you have been scammed. There are some other options that you might want to consider. You do have the option of filing a complaint with the U.S. Patent and Trademark Office. We're not an enforcing agency, but what we can do is that we can put this information, make it available online. Another thing is that you can file the attorneys. Since our attorneys are registered, patent attorneys and agents are registered with the Office of Enrollment and Discipline at the USPTO, you can file a complaint with the USPTO regarding that attorney that's working with them. The FTC, the Federal Trade Commission, is an enforcing agency and can get involved. And then under that American Inventors Protection Act, you can file a civil action suit. And this goes into detail. We can put this information up on the USPTO website. Next. And this is the form that's available on our website. It's under the Independent Inventor. It's links under the Independent Inventors page. Next. Registered patent attorneys and agents, because we have this Office of Enrollment and Discipline, they have to meet certain ethical standards. And so if we do find out that somebody has been basically running a patenting mill type of thing, we can have them disbarred. So this is a possibility if there are meritorious complaints. And this explains some of the things that complaints that you can raise with the attorney. Yes, you have a question?
Yes. Are there websites or do you have a database of companies that are particularly continuously egregious?
We have these very complaints that we talk about. We do provide an opportunity for these invention promotion companies to address your complaints. If they do not, then we post it on our website. There's also a third-party company, a third-party individual who is perhaps much more vigorously than we have putting complaints. So yes.
So complaints go up there if they're not answered, right?
Well, the complaints that we put up there, we had given them the opportunity to answer, and you can actually see what the complaint was, and if they choose to answer it, but they don't answer it to the satisfaction of the complainant.
But does anyone aggravate those? In other words, so can you go up and say XYZ company?
Well, they're electronic. They're alphabetic. But again, here's the catch. Some of these companies are fly-by-night and they change their names. So they're only as good as the most current information we put up. And I'm sorry I don't know the name of it, but I do know that someone has told me that there's kind of a crusader out there who has probably been burned by one of these companies that has put up a third-party website that is not associated with the U.S. Patent and Trademark Office, but you might want to be on the lookout for that. So, then the next few slides just go through some actual cases that went through. These are cases where I'll get to your questions in a second. Actual questions, situations where patent attorneys were charged. Go through the next slide and the next slide. You can file a complaint with the Federal Trade Commission because they actually What they do is they tend to do like class action suits against these companies if they get a lot of complaints. They don't do a lot of individual things, but if they get enough complaints, and they have gone after some of these companies before. So and there's a listing of 3 of them right there. Next. And that information is posted on their website. So the Inventors Protection Act requires that they answer the questions that I talked about at the beginning, and this is just an overview again of things. Again, to give you an educated sense of whether or not you are dealing with someone legitimate. You can file civil suits. So in summary, please use caution with dealing with anyone who says they will promote your invention. I'm not saying that everybody is crooked in that field, but please be careful with whoever you're using. There are, we have the Small Business Development Center, Business and Technology Development Centers here in Arkansas, and as well as in other parts of the United States. And they know, they have worked with other university types of things that have also looked at things like helping people with not only trying to come up with marketing plans, but whether or not, I know they work with small business plans, but also at some of the universities they actually can, for a small fee, they'll actually run marketability studies to find out whether or not an invention truly has potential. That's not the sort of thing we're talking about. We're talking about companies that ask for big money and then promise you things that they really cannot legitimately promise you. Make sure you ask those questions that I had listed there in the list, because they are required to answer those. And just, please remember that registered patent attorneys on whole are outstanding individuals. They're just a few bad characters that are working with some of these companies. And what these companies are trying to do is take advantage of you as an inventor. Inventors have great ideas. They are perhaps excellent engineers, but they don't feel comfortable trying to sell their ideas to investors. And they're taking advantage of that. And I realize that's a difficult thing to do, and I understand that it's a challenge, but don't expect that these people are going to magically appear, and if you just give them a lot of money, they're going to successfully commercialize your invention. And just a few more of your resources there. Now, there are some hands raised for questions. Yes? Over. Yes, back there. Mm-hmm.
Quick question for you. You're indicating that not every one of these companies is a scam, but are you actually aware of any companies that are charging fees up front and are legitimate?
So the question is, am I aware of any company that charges fees up front that are legitimate? And that's not for me to answer.
Okay. You know where it's going.
Yeah. I mean, I don't want to just, but again, that's an outstanding red flag right there, Yes, your question.
If I'm an inventor, are they going to contact me, or how's that, or am I going to contact them somehow, or how's that original connection made, where they find out I'm trying to get a patent?
Well, I mean, you've seen advertisements for these companies, and typically, whether on the internet or on television or in radio ads, it's usually the inventor who is contacting them. At one time at the USPTO, for independent inventors, on the front face of a patent, we would put the address of the inventor. We quit that practice 2 years ago or a year and a half ago. But still, I showed you Public Pair, which is the file wrapper of patents. You can still get that. If you dig a little bit deeper, you can find that information. I'm told by inventors they get inundated by emails a lot, so that's...
So it can go both ways?
I think it can go both ways, yes. Yes?
What process would it be if you wanted to try to request that a database be, if not, just like the new Consumer Financial Protection Bureau has a database of consumer complaints. You can now go online and you can see which credit cards
Well, in this case, it was congressional. It was the U.S. Congress that included that as part of the law. And if you feel that that's not a satisfactory enough approach, because this is a federal problem, also, however, within the state, because you have the state attorney general's office, you can talk to them as well. Mm-hmm. In the far back there.
Yes, sir.
And wait for the microphone to come around.
Okay, you stated earlier that once you file your provisional, you have 12 months to file your non-provisional.
Right.
Okay, now, if it takes several years, sometimes to receive your patent, what protects you in this 12 months until you receive your patent?
So that's a very good question. That is, when does your patent protection kick in? Basically, that's what your question is. You cannot enforce patent protection until your patent issues. Now, but there's a catch to that. With this Inventors Protection Act, one of the other things that kicked in around that time was the 18-month publication of patent applications. And they do allow in the law that if, with the publication of a patent application, if someone starts copying your invention, that once your patent issues, you still have to wait till the patent, you can, well, let me put it this way. If somebody starts copying your invention, you can provide them with notice that you know they're copying your invention, and you can turn around and if once the patent issues, you can get provisional damages. In other words, any profits that they made during that time. Now, when your patent issues as well, you also have the power of going after infringers, a much more powerful protection, because then you can take things possibly into the federal courts. You can possibly get triple damages if you can show willful infringement. You can get attorney's fees paid. I mean, there are many more possibilities available to you. But you're absolutely right. I mean, that's kind of the way the system works. That's what the patenting means, is that you have to get the patent to be able to go after infringers. Remember, it's a right to exclude. You get that right to exclude when the patent issues. You don't get that right to exclude prior to that point. So please, that's all right.
So would I be afforded the same protection, let's say for instance, working on my patent and I didn't go was that track one,
The accelerated examination.
Right. Okay,
Yes.
the accelerated examination. When someone else in another state did that and they received the same patent, they received my patent before I did. So
Well, things are going to change with the new patent law, but under the current setup, if two patent applications come in at the same time for roughly the same invention, the patent can only go to the first to invent. Again, that's going to change, but this only goes to the first to invent. What will happen is the patent examiner will typically notice that because it's kind of channeled to the person in that field. So let's say both of those inventions deal with watches. So the patent examiner in that field will get to those at roughly the same time. Well, you can initiate what's called an interference proceeding, in which both parties have to show evidence of when they conceived the invention. Now, things like lab notebooks, proof that you discovered, or as you were working on the invention, this is what you found. Lab notebooks which have no loose leaf binding to them, that have been pages which have been witnessed by a party that understands what it's talking about. Those are types of proof, and even when we go to a first inventor to file system, that will still be valuable proof of the fact that you are the inventor anyways. But under the old system, which was first to invent, if you conceived the idea the day before this other party did, that was your way of winning the patent over that other party, because it was proof that you were truly the first person to conceive the idea and invent the idea. So that's the type of thing, that's the way those types of things were handled. They were called interference proceedings, and they were handled by a judicial board at the USPTO called the Board of Patent Appeals and Interferences. The interference proceeding will go away once we become, in March 16th of 2013, a first inventor to file country, But there is going to be something, a new proceeding that will come into place called a derivation proceeding, where if you feel someone has borrowed from or stolen your idea, that you can get redressed that way with that board. So there are ways around that. Great questions. Okay, let's go ahead and, if there are no more, let's go ahead and let's talk about trademarks for a little while. Oh, no, we have the film, that's right. Okay, we're going to show you. And of course, this is a great thing because after lunch, after everybody's eating those cookies, what do you like to do? Dim the lights and take a nap. But try not to take a nap. And I don't know how, we're going to try to work this out so that the people watching this at home will be able to hear and see it. This gives you some history of the U.S. Patent and Trademark Office, but then it goes into contemporary times and gives you a real sense of how things work at the USPTO. Can we dim the lights?
Granting of patents, registration of trademarks, training of personnel, processing of appeals, and interaction with the international community is all based on new technologies, created by the very inventors it is now being used to assist. The impact of innovation on the USPTO is also reflected in the agency's Alexandria campus. The buildings are innovative in design and functionality. They are the latest home for the people and activities of the USPTO. The patent system is as old as the country itself. It is included in the founding document of our nation, the Constitution of the United States. Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. George Washington signed the first patent statute into law on April 10, 1790. In 1802, the young government had just moved from Philadelphia to the new capital city of Washington, D.C., built on the banks of the Potomac River. The State Department, including the Patent Office, was assigned temporary quarters near the White House. Later, at Blodgett's Hotel in Washington, D.C., the Patent Office shared headquarters with the city post office. During the War of 1812, Dr. William Thornton, Superintendent of Patents, saved the Patent Office from destruction by pleading with the British commander not to burn what would be useful to all mankind. During the following year, Congress met in Blodgett's Hotel while the Capitol was being restored. The hotel burned down in 1836. All of the patent models and the agency's documents were lost in the fire. During the next 4 years, the Patent Office was housed in City Hall, now the old district courthouse. In 1840, the Patent Office moved to the building that would be its home for over 90 years and is probably most associated with the agency's storied history. French architect and engineer Pierre-Charles L'Enfant had a vision for the site of the Patent Office at F and 8th Street when he laid out the plan for the new capital city. His vision was that it would be a place where America's heroes could be honored. 45 years later, construction began on the Patent Office building, designed by William Parker Elliott and Robert Mills. Perhaps not quite the pantheon L'Enfant had in mind, the building nevertheless became a temple of innovation, the home of America's inventor heroes. Once praised by poet Walt Whitman as the noblest of Washington buildings, today it is the third oldest federal building in Washington, D.C., and is now a museum and art gallery of the Smithsonian Institution. In its first 135 years, the Patent Office had been under the jurisdiction of the State Department, the Department of the Interior, and finally, in 1925, the Department of Commerce. When the Commerce Building was completed in 1932, it was the largest office building in the world, spanning 3 city blocks. The Patent Office took up over 8 acres of office space. The task of moving the Patent Office records into its new quarters took 4 months. The Great Hall, located on the north side of the first floor, which is now the White House Visitors Center, was the Patent Public Search Room. By the 1960s, the Patent Office was running out of space in the main Commerce Building. In 1967, it began moving into new headquarter buildings in Arlington, Virginia's Crystal City. Eventually, the USPTO would occupy 18 separate buildings scattered over a mile. With leases expiring at the end of the last century, the USPTO sought a new home. Through a competitive process, they found one built specifically to serve the agency's 21st century needs. The construction of the campus in Alexandria, Virginia was completed in 2005. It consists of 5 interconnected buildings named for men who played important roles in establishing America's intellectual property protection system. James Madison is generally credited with writing Article 1, Section 8 of the Constitution, which provides the basis for this country's intellectual property protection system. Thomas Jefferson as Secretary of State, William Randolph as Attorney General, and Henry Knox as Secretary of War comprised the first patent board. They met every Saturday to review applications and issue patents. The 5th building is named after Henry Remsen, the first clerk of the Patent Board. The 2 million square feet of the campus houses over 8,000 highly skilled and professional employees. It is one of the largest federal facilities in the country. Modern buildings and equipment and employee-friendly services, including a child development center, multi-purpose meeting facilities, a consolidated training center, a fitness center, and ample on-site parking, give USPTO the opportunity to attract and retain a highly skilled workforce. In addition to space dedicated to the agency's core functions and employee services, the new complex hosts a wide range of public amenities as well, including the Patent and Trademark Museum, a full-service cafeteria, and Delaney Gardens, a landscaped 2-acre park located at the center of the facility. The USPTO campus is an outstanding facility, but what really matters is the important work that goes on here. What happens on a typical day at the United States Patent and Trademark Office? In short, the activities of a day at the USPTO offer a cross-section of the agency's mission and a mini portrait of what patents and trademarks are all about. The patent process begins when an inventor files a patent application and it reaches the Office of Initial Patent Examination. But before we begin that journey, let's go back a moment. What is a patent? A patent for an invention is the grant by the government of a property right to an inventor, which gives the inventor the right to exclude others from making, using, offering for sale, or selling the invention in the United States or importing it into the United States.
If you're an inventor, essentially it's a monopoly that you're granted for a limited period of time that allows you to exclude others from making and using your invention while you exploit the market. So it's a limited property right that's granted to you by the government in exchange for the full disclosure of your invention.
There are 3 types of patents. Utility patents are issued for an article of manufacture, something tangible and functional. A design patent is for the ornamental design of an article of manufacture. And a plant patent is issued for a new or discovered plant that can be asexually reproduced. For an invention to be eligible for a patent, In addition to full disclosure, the invention must also be new and useful.
New means that it's novel, it hasn't been done before. Useful means it has utility, and it works as presented.
The invention must also be non-obvious. This means that if it differs only slightly from what's been done before and would have been obvious to a person of ordinary skill in that field, then the application for a patent might be denied.
That's why we hire scientists and engineers. These are the people of ordinary skill in the art. In your application, you'll have a specification which describes in detail the invention, a set of drawings, if necessary, to show the features of the invention, a set of claims. The claims are the property right that you're seeking.
So that's what a patent is. The journey to becoming a patent begins with the filing of an application with the USPTO. For years, almost all applications were filed in paper format. They were physically assembled and delivered by hand to the proper examination group, which performed the examination in a paper file format. It was a slow and difficult process. Today, an information technology system the Founding Fathers could not have dreamed of has transformed the way patents are received, processed, and examined. This system was developed by the people of the USPTO, working closely with the Office of the Chief Information Officer. With this new system, applications are submitted electronically through the Internet or scanned into electronic format, which is the business process that the Patent Office uses to examine applications.
This allows for multiple points of access to a single application. Applications are no longer lost, misplaced, or unavailable as they may have been in the past in paper format.
The USPTO's electronic filing system is simple, efficient, and secure, and provides inventors with a receipt within minutes. Once filed, inventors can track the progress of the application through the Patent Application Information Retrieval, or PAIR system, on the USPTO's website. With over 400,000 patent applications filed per year and 100 million pages scanned into electronic format, it's easy to understand how invaluable the application of 21st century information technology can be to the process. Once in the system, the application is reviewed and an initial decision is made regarding the classification of the subject matter. Nearly 9,000 applications per week are reviewed and processed in the Office of Initial Patent Examination. Once classified, the application moves electronically to a patent examiner with expertise in the appropriate field. This same information technology also speeds up the process of the examiner, who will use it to research the prior art.
Prior art is essentially U.S. patents, publications of patent applications, anything that's in the public domain prior to the invention.
If the invention, or something very close to it, has already been patented, the application for a patent may be denied. Researching prior art in a paper-based system was time-intensive. In a digital world, prior art documents are available through search engines on an examiner's workstation, the databases of the USPTO, foreign patent offices, commercial entities, and the Internet. In the old days, paper files were stored in drawers called shoes. It is said that Thomas Jefferson, as a member of the first patent board, kept patents in wooden shoe boxes. This practice is how the term shoes originated as a description of the filing drawers where paper patents are stored.
We had 5 10-story buildings filled with these patents. And there's a classification scheme. I think when I came into the office, there was 128,000 different classifications of invention. That's the old paper classification system. Modern system, we have the ability to search by classification electronically, the ability to do keyword searching and string searching.
Such computerized search techniques are invaluable to examiners who carry heavy caseloads in an increasingly complex and growing body of prior art. Currently, there are some 160,000 different classifications of invention in the U.S. patent classification system.
Examiners work on a stream of applications. They may have 100 new cases that are up for action that haven't been looked at yet. They may have 60 cases in their rejected docket that they've acted upon and they're awaiting a response by the applicant. And they may have 30 cases in their amended docket that are awaiting action from a response to the applicant.
The review process may include back and forth discussions with the applicant about the patentability of the invention. Ultimately, there is a final resolution of the application when a patent is granted or denied. Its journey is complete. Trademarks are as important as patents in protecting the intellectual property rights of individuals and companies. In 1870, Congress enacted the first U.S. trademark law. It was later declared unconstitutional because it was improperly based on the patent and copyright clause in the Constitution. It wasn't until 1881 that a new law based upon the Commerce Clause was passed. Trademarks offer a different kind of protection from that of a patent. While a patent protects an invention, a trademark serves to identify the source of goods and services and distinguishes the goods and services of the trademark owner from those of his competitors. Trademarks protect consumers from being misled and protect the reputation that the trademark owner has created for his goods and services. A trademark can be a word, a phrase, a design, or something more unusual, such as a scent, a color, the three-dimensional shape of a product, the packaging of a product, or even a sound.
You've got mail.
A patent grant affords the right to exclude others from making, using, or selling particular goods that are covered by the invention. Trademark, on the other hand, doesn't prevent someone from making, using, or selling the goods, but rather prevents someone from using the same mark that's used to call on those goods.
Also, while the USPTO will grant a patent to the inventor, it does not grant a trademark. What it does is register a trademark. A trademark may be registered when it has been used in commerce. Certain international treaties also may serve as a basis for registration.
All we are doing through the federal trademark registration process is verifying the applicant's use and making sure that it is in accordance with the statutory provisions of the Lanham Act and our regulations. The Lanham Act, it's the act that grants the Patent and Trademark Office the authority to register trademarks.
Another difference between patents and trademarks is the length of their terms.
A patent is limited to a 20-year term and is not renewable.
The trademark, as long as the trademark owner continues to use the mark on the goods and services, may be renewed every 10 years.
Like the journey of a patent application, the process of registering a trademark takes full advantage of the electronic tools that are now available.
The modern trademark application and examination process is highly automated. From the moment it comes in the door till the moment the registration is issued, it's a nearly paperless process. You can apply directly for a trademark using our Trademark Electronic Application System, or TEAS, online. In fact, more than 90% of applications are filed this way.
Once the application data is loaded into the computerized system, it gets forwarded to an examining attorney for review.
The trademark application will actually be electronically queued to their docket. The examiner will open up the application on the computer system.
The examiner will search the USPTO's database to be sure there are no similar existing marks that would create a conflict or confusion between the two. The application also must indicate the goods and services the trademark identifies and must include examples of how the trademark is used on the applicant's products or services. As with the patent application, there is a definitive end to the journey of a trademark application through the USPTO's electronic system. The proposed trademark will be registered or rejected. Because of the critical nature of their work, patent and trademark examiners are chosen for their experience and put through rigorous training.
Present of the application to issue the case. You want to make sure that all
Patent examiners are often qualified by their past technical experience in the fields of engineering or science and will be assigned to a division that focuses on patent applications in that field of expertise.
the case to your LIE.
They're sent to the USPTO Patent Training Academy for the first 8 months of their career. They learn practice and procedure, and they have instructors and mentors in a classroom setting. They will work closely with a senior examiner or a supervisor who's familiar with the technology that they've been assigned to.
What was the GA?
In the course of the training, examiners learn the legal precedents for examining and judging applications. They learn how to dissect an application, how to analyze what an applicant is claiming, and how to research prior art.
Unlike patent examiners, trademark examiners are licensed attorneys. We have a very extensive training program in which we put them into a classroom setting for approximately 12 weeks. At that point, they will be assigned a mentoring attorney who will work closely with the examiner over the next 2 years at varying degrees of oversight.
A definitive action by the USPTO will ultimately bring the journey of an application to a final destination. However, under certain circumstances, that journey may be extended. If an application for a patent or a trademark is denied by an examiner, the applicant has the right to appeal. The appeal may include an oral hearing before the Board of Patent Appeals and Interferences, or the Trademark Trial and Appeal Board.
There will be a panel of 3 administrative judges in each case.
Can you explain to me the exact claim?
These judges are all attorneys with experience in patent law.
It's a catalyst that's involved in deliberate.
A hearing may also happen in the case of what is called interference.
An interference is a situation in which basically 2 patent applicants are applying for the same invention. And the function of the board in that case is basically to decide who has priority to that invention.
Similarly, with trademarks, companies or members of the public can oppose a proposed mark or seek to cancel one that is already registered if they believe that they would be damaged by the registration of a mark.
Way is functional, and yet that results in a shape.
Here again, with the appeals process, the USPTO utilizes 21st century information technology.
The filing of the appeal is electronic. The record from the Trademark Examining Corps is available electronically.
In addition, video teleconferencing allows testimony to be presented from remote locations. In today's global economy, U.S. patents and trademarks are widely sought by individuals and companies throughout the world.
Intellectual property is becoming increasingly important in the global economy. We provide training all over the world to officials in the area of intellectual property everywhere. Seminars and programs for judges, for prosecutors, for investigators, for intellectual property officials of all kinds, to develop systems and laws to make sure that those countries have the best intellectual property enforcement systems that is available. We also have a global IP academy here at the U.S. Patent and Trademark Office geared towards intellectual property officials from all over the world to improve their intellectual property legal and enforcement systems.
The theft of intellectual property through piracy and counterfeiting is a major focus of the USPTO's Office of International Relations and Enforcement.
The intellectual property of American businesses is often being stolen in countries all over the world. And so that's why the enforcement section has become so important, because we need to make sure that we can help American businesses secure and enforce their intellectual property as much as possible all around the world.
The STOP initiative, Strategy Targeting Organized Piracy, is a key to the government-wide effort to combat piracy and counterfeiting. The STOP initiative gains its effectiveness by combining the resources of the USPTO with those of the Department of Commerce, the Office of the U.S. Trade Representative, the Department of Homeland Security, the Justice Department, and the State Department. USPTO databases are open to anyone. People can access this wealth of information on U.S. patents and trademarks over the internet from any location in the world. Or they can make the USPTO campus their own office through a personal visit to the public search room.
Today, we have about 250 visitors that come each and every day to this facility to search for information on patents and trademarks. About 60% of those people are professional searchers. Another 33% are attorneys and agents that are registered to practice with the office. And the remainder are students and inventors that come here just to get information about patents and about trademarks.
The old search room consisted of acres of papers on shelves in cabinets. Only one person at a time could review a given stack of papers.
So if you're looking for washing machines, you're the only person in the entire room that could look at washing machines. In the past, you would come in and you'd have to spend time going through a manual of classification by hand, figure out where you needed to be, then you'd have to go look on the map, try and find it, go through 2 or 3 floors to find that particular section of shelves, then you stand there. It could take quite a long time.
Today's search is virtually instantaneous, and it's free.
Today, we've got hundreds of computers in this facility where hundreds of people can sit down and search on the topic washing machines simultaneously and all get their answers with their little special nuances, and they don't have to wait on anyone else. They also have access to more information than they've ever had before.
This access to information is the most visible symbol of the way technology has transformed the USPTO. From the days of patents in shoeboxes, and when secretaries copied patents by hand, one word at a time. On an average day, over 3 million people from all over the world use the USPTO website to obtain information about patents and trademarks and to conduct business with the USPTO. The Founding Fathers had a dream of how intellectual property protection could play a vital role in assuring the greatness of a country that was itself an invention. But it's unlikely that even these visionary men could have dreamed of how their system to promote science and the useful arts would in turn transform the United States Patent and Trademark Office itself.
I can certainly say too from the video, especially when you saw the public search facility, the current public search facility, the old public search facility, and the old search room with all the paper, brings back a lot of memories. There's a lot of people in that video that I can remember, and with the old paper shoes, and literally we had in the old search facility before we moved to the current one, we had literally 500 miles of shelving. So
the thing that was unusual about that search facility is there are 8 million U.S. patents, but every time you had a U.S. patent in a different class and subclass, they made a copy of it. So when they would go through those wooden or those those shoes, those groupings together, they were based by class and subclass. So, for example, we were looking at that patent earlier that had had about 8 classes and subclasses. So that would be copied 8 times and would be in 8 different shoes. So it made it very easy for somebody to do a manual search to quickly flip through and look at the front pages of the patents. What did we see on the front page of a patent? A representative drawing, an abstract, a title, and they would set aside the ones that were of the most interest, and then of course they would look at them in detail. And for people who are used to this very old-fashioned method of doing it, it was a real, some people just retired.
Oh,
And some professional patent searchers.
And a couple of things that are of interest on that for me. When we began with the electronic search systems, the flip rate from one image to the next image, many of our experienced professional searchers found that they could flip through the paper patent faster than they could do electronically. So they stuck with the electronic, with the paper rather than going to electronic. Then, of course, it's much faster today. And then the other thing that, as Tom was mentioning, you know, like with that one patent we were looking at, we take 8 copies of it. In the last 2 years, we were
this is fine.
we're issuing patents once a week on Tuesday, right? We're issuing patents like about 3,500 patents every week. Well, that meant that by the end of the week, we had to file 3 times, on average, 5 patents per, for the 3,000. So we're filing about 18,000 to 15,000 new copies of patents in this 500 miles of shelving. It's no wonder we went electronic. But the amazing thing was, by the end of the week, all the copies were in place for people to search. That wasn't my job. Okay, I'm just going to tell you that right now. We had contractors who did that. All right?
Now we're going to shift gears and talk about trademarks. You had a nice kind of visual introduction to trademarks and that. Before I get started, I do want to remind you, I thank all of you for staying here so long today. We do have an evaluation sheet, this yellow evaluation sheet. We really would appreciate it before you leave, if you have to leave early. And I want you to stay, but if you have to leave early, please fill this out and just drop it off at the table that's outside. It's not only valuable to us at the U.S. Patent and Trademark Office, it helps us do a better job of giving a presentation, but also the folks at the State Library and also the folks at the Small Business and Technology Development Center are interested as well in finding that, finding how you felt this program was, and if you'd like to see additional programs like that. And by the way, there's one thing that's really valuable when we do these things, is that first line. How did you hear about this program? We're always, for anybody who does any type of programming, we always want to know how did you hear about it. So please let us know what's more effective means to let people know about programming. Now on the left side of your white information packet, you have trademarks, the 7-step strategy for doing a search strategy. Trademarks, the benefits of federal registration, which I've already addressed in one of the earlier slides, and this kind of reddish-orange booklet, Basic Facts About Trademarks. I will be referencing a little bit of this booklet later on. Now, Neil, if you go ahead and get started on the presentation. As you heard earlier in the movie, the film, a trademark can be a word, a logo, a word and a logo, or some other device used to identify and distinguish goods or services from other goods or services in commerce, sold in commerce, and to act as a source identifier. Neil? So what types of things can you help, what type of help can you get at a PTRC, a library that's a PTRC that you can't get at home if you go on the internet? Because after all, you can do trademark searches at home. But one of the things that you can get is what you're going to find out today, and that is you can get trademark guidance on how to do a more effective job of doing a trademark search. If you go back to the previous slide, I do want to point out something, Neil, and that is that librarians are not required nor encouraged to conduct trademark clearance searches for people. So they can show you, just like as you saw in the patent example, they can show you how to do a search using the example. They just cannot do that particular search for you. Now, does that mean they can't do other types of, help you with other types of trademark searches? Yes. If you're looking up the trademark of a company, if you're looking up the history of a trademark, they can help you with that. But we're talking about trademark clearance searches, which is what you're trying to do before you file for a trademark. They cannot provide legal advice in any guidance they would, suggestions they would make, well, try this, try that, might mistakenly lead you in the wrong direction. So we do not ask them to do that. But they can help you using an example, just like we did with the patent side. Unless you're really, really lucky with the patent side and your patent is for a heated dog dish. But other than that, you have to kind of apply that to what you want. So what happens at one of these libraries? Well, someone comes in and the librarian can show them the common errors that people make in doing trademark searching. For example, the most common error of all is that many people assume that all they have to do if they have a trademark is to go onto one of these databases and search for the exact spelling of that mark. And they think, and if they come up with 0 results, they think, well, great, I can go ahead and apply for that trademark. While in fact, that's not enough in doing a trademark search. Many assume that all they have to do is search for the exact spelling. And as I said, if the mark doesn't appear, they think they'll get registration. Whereas, if there is a registered trademark out there that is similar, not spelled exactly the same, but similar to theirs in sound, appearance, or meaning, where the products or services are the same or related, then it's going to be rejected by a trademark examiner at the USPTO. Why? Because the likelihood that consumers would be confused by the coexistence of those two marks in the marketplace and commerce. This is really a key refusal that trademark examining attorneys at the USPTO give. Likelihood of customer confusion. They'll ask themselves, if you go back, they'll ask themselves, would customers likely believe mistakenly that the goods or services come from the same source? And if yes, it's going to be refused. Now, what do they compare when they're doing this trademark examination? Well, first, they're going to look at the sound, appearance, meaning, and commercial impression of the mark you're applying for compared to all those marks that are on the Federal Register. And they'll also compare the marks as the goods or services that are involved. Are they related? How are they used? How are they marketed? What avenues are they marketed? Now, this is a real-life example. I have a colleague who found this at a garage sale. Now, if you had to make a quick trip to the grocery store or the quick trip to the drugstore, you need to buy Crest toothpaste. You might mistakenly buy this thinking you had bought Crest toothpaste. It's not spelled exactly the same as Crest, but the packaging certainly looks a lot like Crest, and the word is somewhat similar in sound and appearance to Crest. But this is not from Procter & Gamble. This was from a company in India that actually applied for a trademark for this, and it was abandoned. I don't know the full story. I'm not picking on this company. I just thought that this was a great example of something where it's very, very similar in look and feel, but not spelled exactly the same. Well, this is kind of the basis of our trademark protection, in that we want to avoid something like this happening. We want to avoid providing trademark protection to a company for a mark that's confusingly similar to marks that are already out there that you and I know. Companies spend millions of dollars not only in advertising, but establishing goodwill with their products, goodwill with their services. And if we allowed other marks to be approved that were similar, then customers would be confused and they would lose a lot of money. Now, one thing I do want to make clear, however, if the goods involved or the services involved are not related, the same word can be allowed as a registered trademark. Ford has an automobile named the Fusion. Gillette has a razor named the Fusion. There is a golf club, a Big Bertha Fusion Golf Club. Very different types of goods. It's unlikely that someone would think that Ford has suddenly gone into the business of making razors. So they will allow a word or a phrase to be used and registered, provided they're very different types of goods or services. Why? Because it's very unlikely that customers are going to be confused by the coexistence of these products out in the marketplace, because they are so different, they are sold in different areas and advertised in different commercial channels. So just remember that, because I find that's a mistake the media frequently gets with trademarks. They think that once a word or a phrase is trademarked, people assume, oh, nobody else can use it. Well, that's not true. They can use it for a product or service if it's a very different type of product or service. So why would you bother to conduct a trademark search before you put in your application? I mean, after all, at the USPTO, they're going to do a trademark search, correct? Well, that certainly is true. But you potentially could save yourself a lot of money. Why pour all that money into advertising or creating the product and then find out it's going to be rejected because it's too similar to something that's already out there? It may not be something that you've seen advertised locally, but in order to get a federal trademark, for example, you don't have to be selling the product in all 50 states. You just have to be selling the product across state lines. So that trademark may be federal, there may be a federal trademark, and they may just be selling it, let's say, in Massachusetts, in the New England area. It may be out of Massachusetts, but they're advertising it to people in New England. So the way you can catch these sorts of things is to do your preliminary trademark search ahead of time. The other value of doing trademark searching is on the opposite end. Once you get a trademark and you start using the mark on a product in commerce, the onus is on you to protect your trademark and to be on the lookout for marks that have been, that perhaps the USPTO has mistakenly approved and you feel is confusingly similar to your own. Now, I asked Michael to check for the old Official Gazette for me. This is a copy of the Official Gazette. This is still published in print format by the USPTO. It's no longer sent to libraries. You have to subscribe to it. It's available on our website in electronic format. What do you see here? You see, all you see here are marks that have been approved by a trademark examining attorney at the USPTO. And when they appear in this weekly publication, for 1 month, you may oppose it. It's called Publish for Opposition. So companies hire paralegals to check this database. It's also in a database, but also in a PDF form, to see if the USPTO has, in their opinion, mistakenly approved a mark that's similar to theirs in sound, appearance, or meaning, where the goods or services are the same or related to what they're selling. The Official Gazette, it's published for opposition. Well, they can file opposition proceedings with a judicial panel, and you saw a picture of that judicial panel in that film. On the trademark side, it was called the Trademark Trial and Appeal Board. And they're essentially appealing the ruling of a trademark examiner. They're opposing it. And if they can provide evidence that the trademark examiner made a mistake, they can stop the trademark from going forward. One final reason why people search for trademarks, it's not in the slide here, but sometimes people are searching regarding the history of a company. Just like over on the patent side, sometimes people are interested in patent information, perhaps because they had a relative, they found that a relative had an invention and they're doing genealogical research. The trademark database is a great history of commerce in the United States, and sometimes people are doing historical research trying to track down a business or a product using the trademark database. How much does it cost to file for trademark protection? Well, compared to patents, it's far cheaper. A paper filing is only $375 per international class. And if you file electronically, you get a $50 discount. If you file electronically and all of the future correspondence with the USPTO is all done electronically, you get an additional $50 discount. I ask you to take a look right now at this Basic Facts About Trademarks booklet. And if you will look at the last few pages, you will see on page 17 something called the International Schedule of Classes of Goods and Services. Now, Neil Masong showed you earlier the U.S. patent classification system, which looked pretty complicated, didn't it? Well, this is far simpler. Rather than, as they've done with U.S. patent classification, which is to take inventions and break them down into different types of categories. These are broad categories of goods and services that are sold in commerce, and they've broken it down to only 45 possible categories. Well, these 45 categories are the basis for determining how much your trademark application is going to be. So let's say you're University of Arkansas and you're the Razorbacks. And let's say that for both online and at the college and college bookstores and what have you, that they're going to sell clothing. Well, look at class number 25. Well, something with the Razorbacks insignia logo that would be T-shirts and hats and sweatshirts and you name it. All clothing fits into that one category, class 25. So all it would cost the university if they filed electronically, the cheapest way, would be $275, and it would cover all different types of clothing. So it may be, depending on whatever types of goods or services that you're selling, it may be it only falls into one of those international classes since they are so broad. So it may be that that may be all it will cost you to file for trademark protection for a federal registration. But if it falls over, if the goods that you're putting your mark on fall into more than one category, you will pay the additional fee based on how many international classes that you're covering. There's more detail on these international classes in Chapter 1400 of the Trademark Manual of Examining Procedure, which is online. The Manual of Examining Procedure is kind of a guidance that's provided to our trademark examiners, but also the public can learn a lot about the guidance that trademark examiners have to use in determining how to examine a trademark application. So application requirements, they're very, very simple, very basic. You see them listed here. The one thing that I would point out, well, I'll point it out in a minute because they're two bases that you can file for trademark applications. If you go to the next slide. When you file for a trademark, you can file based on use, actual use of a mark in commerce. You're already using it in commerce, so you're using it on your to advertise your restaurant, let's say for restaurant services, and it's filed based on use. If it's filed based on use, you provide to the U.S. Patent and Trademark Office in the application a specimen. The specimen shows how you're using it. If it's services, typically that is shown by taking an electronic photograph of advertisement, because remember, services are intangible. But if it's a good, frequently the container or perhaps a tag or something. This shirt is like, I think it's like a Land's End shirt. So the tag, you know, the shirt tag, that shows the logo, the trademark, that would be used as an example of a specimen showing that clothing trademark. But you can also file another way, based on intent to use. If a company is considering using a word, or maybe more than one word, for upcoming products, and they think they've come up with a great name or great names, they can file based on a bona fide intent to use. In that case, they don't have a specimen because they're not actually using it in commerce. But they're going ahead and filing it, and then what they have to do is, every 6 months, they are given the opportunity to renew this until a total maximum of 3 years. And if by 3 years' time, after these every 6 month renewals, they have chosen not to use that word for a mark, they abandon the mark. They can't keep holding on to it forever and keeping other people from using it from that type of product or service. Sometimes you can see some interesting things if you go to the trademark database online to find out what products maybe your competitors are interested in using, intending to use, considering to use. For example, in the automotive field, Many of you may have grown up remembering that back in the 60s and the 70s, Buick had a car called the Riviera. I saw an article recently saying that they had GM once more had filed based on intent to use to revive that word for automobiles again. They filed based on intent to use, which means they aren't using it yet, but they have put their foot in the door, and if they do choose to put that on another automobile in the future, then they'll send a specimen in showing how they're using the mark. Now, the other filing basis that I don't show up here are based on are from companies that are coming in from from other countries, or filing based on their international use in another country. That wouldn't apply to small businesses in the United States. Next. One of the great things about the folks over on the trademark side is they've created a lot of informational videos that are not only very useful and easy to understand, they're also kind of clever. They've kind of made this as if to kind of give the look and feel of a news studio. And all of these different topics right here they cover. So you might, I always tell our librarians to show people these so they'll know about them. If you're going to file for trademark protection, please consider looking at these. They are produced by the folks over in Trademarks, and they've got about 11 of them now. They've also put them up on YouTube. Next. And this brings us to searching, and that is how to conduct a thorough job of doing a federal trademark search. So we're going to go into some detail on that, and so let's do that right now. On the USPTO homepage in the top right-hand corner, rather than clicking on Search for Patents, click on Search for Trademarks. That will bring you to this page, TESS, the Trademark Electronic Search System. There are 3 search formats. The first one is a very basic one. It gives you limited search options. And I don't typically show this to people I'm helping because a true search strategy involves more than just a basic word search. But in this example here, I clicked on basic word search and put in the word Starbucks. And if you see the next slide, I guess I have no, I don't have my results there. But it would give me a list of any mark where that word phrase would show up. The second search form, the structured form search, allows the entering of up to 2 terms. The first, I'm searching for the word mark Dell in the basic index, which is where all the word marks are. I can select the Boolean operator AND, which means it also in the search would have to have the second search term, which is the word Texas. I'm looking in the owner name and address field. But what am I looking for? I'm looking for Dell. I know Dell Computer is somewhere in Texas, so I'm putting those 2 together and hoping that I'll find all the trademarks that Dell owns, that has the word Dell in it. The freeform search, however, I have to enter these things, these different field codes, which with trademarks have brackets around them. What I've done is I've come up with a search where I'm not only looking for Dell in Texas. It turned out that when I ran that search, it found there were a few Dells that had nothing to do with Dell Computers in Texas. So this time I made it look in the owner name and address field for Round Rock, because that's the headquarters, town of the headquarters. And then to even focus it even further, I want all the live marks. What's a live mark? Well, remember I said that trademarks can be renewed. If you don't renew your trademark, it's going to die. It's what's called abandoned, canceled, or expired. And those are referred to dead trademarks. And they're dead as far as the USPTO is concerned. So what I wanted there is to take all of those marks, but I'm just only interested in the ones which are live. For example, of a dead mark that Dell used to use, remember they used to have the slogan, what was it, dude, you just got a Dell or something like that. You remember, they used to have the commercials about 10 years ago. The TESS database, these are some of the most commonly used fields in the TESS database, and we will be using these fields as we go through the multiple step process. Next. So here we're going to, just like we did with patents, we're going to come up with an example and follow it step by step. Let's say that you are going to sell a new brand of mouthwash, and the mouthwash is called Cool and Fresh. And notice how you're spelling Cool and Fresh, which you think is clever and distinctive and will help be easily identifiable by customers. Now, on our next slide, step number 1, just like with patents, we had to describe our invention. Here we're having to describe what types of products or services we plan to use Cool and Fresh on. Well, this one's simple, mouthwash, which is the next slide. Step number 2, that may be what I would call it, but at the U.S. Patent and Trademark Office, in a trademark application, you need to check and make sure the terminology is part of an approved terminology. Because if it is, you get that really bonus discount of T's Plus, which requires that you take the description from a controlled vocabulary list. It's in something called the Acceptable Identification of Goods and Services Manual, which was previously a formal manual, print manual, and is now all electronic. So I'm going to see if that word mouthwash and the spelling of, is it mouthwash or mouthwashes plural or something else? I'm going to see if that's approved. To give you an example, if there were tennis racket, there's the English spelling of tennis racket and the British spelling of tennis racket. Well, only one of those two is allowed in this controlled vocabulary. So how do I go to this manual? Well, on the navy blue bar that goes across the masthead of the homepage of the USPTO website, under trademarks, there's a drop down. I select Manuals, Guides, Official Gazettes. It comes to this page and I click on the link to that manual. And this is what the interface looks like. I put in the search term that I want to see if it's actually, remember, we want to see if it's an acceptable term, an acceptable identification of goods and services. Click on Submit Query. And I got this, this set results list. Got 11 results. The word mouthwash, or either in singular or plural, appears in all of these. Any one of these 11 would be acceptable to use. So there's quite a variety here. In this case, both the singular and plural are allowed. So I'll just do like you see in the third one there, mouthwash. Next. Next is to determine the international class. Now, when you file for trademark protection, unless you're filing for the cheapest method, which is T's Plus, which requires you to provide the international class, normally what happens, the examining attorney will look at the description of your goods or services and come up with an international class. But for our search strategy, it can be valuable to know if we fall into more than one international class. Well, it's easy. In our next slide, we found it in that column that was right by the listings of the acceptable terms. Those were the international classes, 3 through 16. You'll see number 3 in your list on page 17 here. And mouthwashes is perfectly fine to use international class 3. They use a 3-digit format, so I'll say 003, and we'll use that in our searching. Now, it's not enough just to know the class that mouthwash is in, but are there related classes, and are there related goods to mouthwash? Well, here's one way we can find out. We can look in something called the coordinated class field. You may recall that this list was on the advanced search form, and it was a list of all the different field categories. There was something here called coordinated class. What they've done is, if you see on the next slide, this is like a cheat sheet for searchers. If you search by 003 in the coordinated class, not only will it search the international class 3, but it will search all of those other related classes as you see past it. In other words, they've kind of figured out in advance what the related international classes are. So it saves you some time and effort. Now, on the next slide, the other thing you can do, if you, in addition to looking at the class approach, you ask yourself, you can just do some brainstorming. What are some other goods out there that are similar to mouthwash? In other words, if you are related in some way, if you were a customer and you were going along the shelves at a store, drugstore, or a grocery store where mouthwash would be, well, you'd see things like floss, you'd see things like toothbrushes. So you come down with a list of things that are sold in the same types of stores, advertised in the same types of advertising channels. And now's the time, now that we've done this part, we need to develop a basic search strategy using the main phrases, the main keywords in the mark. In doing so, we can employ truncation. Truncation is frequently used in database searching. What does that mean? Truncate something means to cut off something. So in truncation, using certain symbols, you can look for word strings, either a word string that appears in the middle of a word, at the beginning of the word, or in the end of a word. So for example, the question mark will indicate one additional character. For example, R question mark P in the basic index field where all of the word marks are, will find any of those. But what the question mark cannot do is take the place of a space. In the basic index field and in the translation index field, which is what we're going to use if we're looking for word marks, the truncation character is the asterisk. So this is very powerful. Why? Because we're looking for things that look like or sound like something. And by virtue of the fact that we use this powerful feature of the database, we can find marks that are similar in sound or appearance. In this case, TRAC with an asterisk on either side can find that word as it appears in all those different trademarks. So let's apply this to cool and fresh using the spellings that we have in our trademark. As you see in this list here, that's what I've done. I mean, I've done because this has two very simple components, one-syllable components, cool, fresh, and the N, which is kind of takes the place of and. Now, that's a basic search strategy using the exact spelling of the words in our mark, or the distinctive elements of the words in our mark. But we need to broaden our search strategy. And remember, I said part of what's involved in doing a comprehensive search is looking for marks that are similar in sound, appearance, or meaning, where the goods or services are the same or related. So are there alternative spellings to your mark? Those in that first example are all different ways that woolly bear could be spelled. Are there words that have the same meaning as your words, as your mark? So fun video, but if your mark is fun video, you would also want to search by fun movies or fun films to find out if there are marks that are similar in sound. While you can do that truncation with a question mark, you can also try switching out vowels, for example. For that examples, that's what we've done there with granola. Or are there phonetic equivalents like freshen versus freshen? So this is what I'm doing now. Cool and fresh. I'm trying to come up with broadening my search strategy a little bit. And cool is normally spelled C-O-O-L, so we've done that there. Cool might be spelled in a phonetic kind of way this way also. Again, you're trying to use your imagination to come up with variants. And now we're going to actually conduct the search in the TESS database. We do want to search both live and dead marks for a reason I'll explain in a minute. So going to the home page, clicking on Search for Trademarks. What I'm going to do now is run through, in these examples, some different search statements and show you what we look at when we do this. In this first example, I'm taking cool and fresh using the spelling as it appeared in the mark. I'm ending together the words. I'm using truncation on both sides of the word string. You see it at the top. And when I search, I'm looking in the basic index, which is where all word marks are, in the translation index. And what the translation index will do is that if there is the translated equivalent of it in another language and someone has applied for it, it typically will catch it. And so we just as you see, I put a comma between those. This is what all our trademark examining attorneys do. So I run the search, and let's see what I find. In this case, I only found one. And this one is a bit of an odd one. It's called Ikula. I think it's like Hawaiian or something, but it is a dead mark, and it deals with bottled water, and it was filed based on intent to use. Well, is this, the process that this goes through, first of all, we ask ourselves, is this similar in sound, appearance, and meaning to cool and fresh? Well, I don't know. It's an oasis of refreshment, Ikula, so that's why it pulled up. But it's not particularly close at all to that. And it's not really similar. It is a type of a liquid, I guess, but it's is certainly not in, would be found in like the medicinal dental aisles of a drugstore or a grocery store. So it's unlikely that this would pose a problem with our trademark. Let's go to the next example. In search strategy 2, I'm going to try to include, using my modified search approach, but rather than cool and fresh using that peculiar spelling I had in our example, I'm going to spell cool and fresh like they would normally be spelled. When I click on Submit Query, this is what I get, 81 records. And so what I would do in this case, I would go through each one of these, and I would ask myself, first of all, I think I want to show you a slide that's going to show you the questions I'm going to ask. And let's go back then. I'll go over them. The first question I would ask as I look at each one of these, one, is it similar in sound, appearance, and meaning to cool and fresh for the mouthwash trademark we're asking? And I would click on those individually and open up the record, because then, even if I do feel it's similar in sound, appearance, or meaning, I ask the second question, are the goods or services they're selling the same or related? And I would go down this whole list to do that. Now notice to the far right there is a column that says live or dead. All this means is, you may recall me saying earlier, if a company fails to renew their mark with the U.S. Patent and Trademark Office, as far as the U.S. Patent and Trademark Office is concerned, its status is dead. But you know what? That doesn't mean that company has quit using that mark in commerce. It merely means they forgot to renew that mark. What did I say earlier this morning? Rights in trademarks come by use of a mark in commerce. They don't come from registration. Benefits come from registration, but rights do not. So just because a mark shows up as dead in the USPTO's Federal Register database, it doesn't mean that indeed that company has quit using it entirely. And that's why when I'm showing people how to do searching, I would say just because it shows up as dead, it doesn't mean it's truly dead. You shouldn't just ignore it because it shows up in dead in our database. It still may be in use. So I would go through each one of those 81. Here's another search, but this case, I'm going to focus my cool and fresh, because after all, there were 81 of those, this time on the coordinated class with 003. Remember, the coordinated class takes 003 and it expands it to all those related classes, those coordinated classes. So it's a little bit more focused search than what we had previously. And I got 29 results. Of these, 3 are live marks, but I would view all of those. Next one. Remember, this is the 2-question test we're going to go over. First, is this, as we look at each one of these, number 1, is the mark similar in sound, appearance, or meaning to the mark we hope to use, which is cool and fresh? If the answer is yes, then we go to the second test. Are the goods being sold, which is mouthwash, the same or related? If the answer is yes there, then it could pose a potential problem for that mark we want to use, and maybe we might want to consider coming up with some other names for our mouthwash. If not, they won't be in conflict. So I'm going to go over some of these search results I found. I'm not going to go over all 81, just going to go over a few of them to give you a sense of some of the things I found. This one is called Cool and Fresh. Notice the spelling. But it's for air freshening preparations. So the answer to the first question about sound, appearance, or meaning is yes, they are similar. But are the goods the same? No, they're not. So it wouldn't pose a problem. The second one, fresh and cool. Women and men's perfume, etc. Deodorant. Similar in sound, appearance, or meaning? Definitely. Question 2, are the goods the same or related? They're not the same, but they are related because they're kind of sold in the same marketing channels as mouthwash. Might pose a problem. Next. Cool Fresh, one word. And these are freshening and deodorants for refrigerators, vacuum cleaners, and auto air fresheners. Similar in sound, yes. Similar goods, no. Cool Fresh, mouthwash and dentifrices. Yes to both questions. So then that brings the next question that I would ask myself, because this one does pose a potential conflict. Is it live or dead? Well, this one was dead. And you actually have a button that you can click on a trademark record called TARR, which gives you the current status of the record. And this one gave me some detail. It told me that the registration was canceled because they did not file an acceptable declaration under Section 8, which is part of the renewal process. So I don't know exactly that it's truly no longer being sold in the marketplace, but we know as far as the USPTO is concerned, they just did not renew it. Definitely might be a real problem for our trademark. Here's another one, Aquafresh. We've all heard of Aquafresh before, Pure Cool. And this one is exactly for a mouthwash. And again, similar in sound and dead on as far as the goods are concerned. However, this is a dead mark. It was abandoned. Basically, what this is telling me is that they filed based on intent to use, and they never followed up with it. So they'd actually apparently never used this mark in commerce. Next one. Well, we found enough examples there that I think as a potential trademark user, and if I'm not currently using it, I think these are a little bit too close to the mark that I'm hoping to use. But if I'm really dead set on using this mark, I would hire an attorney to do further research to indeed make sure that those last two marks that are dead are truly, that there's no possibility that they actually are in use and might pose a problem. So the question is, if a mark is listed as dead, can I use it? Well, the answer is maybe. And the way you can find that out is by doing, like I said, either doing more thorough research on your own or having an attorney make sure that there are no rights associated with the use of the mark. Next slide. Now, the coordinated class, remember, added a lot of additional classes. And how could we narrow our search down if we did that? Well, I wanted to show you that there are a few ways you can narrow down a search. Rather than searching the coordinated class, which not only was 003, but 5 or 6 others, we could specifically say just that international class 003. Or we could specifically and our search statement with the goods being sold, mouthwash, or related goods like toothpaste. All of those will focus our searching, narrow our search results down. So if you do have lots of search results, you can find more focused search results by anding those together in your search strategy. And a final step in this multi-step process, what if your mark includes a design element? We have 4 marks up here, and they all have design elements. Heineken has a 5-pointed star. There's a basketball player there. Waffelmeister has a chef in a chef's hat, guy with a mustache. It's got a red circle and then a black square. And those are X's and O's and triangles and rectangles in that one. What if your mark has words and design elements like these two do, or if they're strictly design elements? Is there a way to search them? And the answer is yes, there is. So let's take our Cool and Fresh example, and let's say we were going to include for our mouthwash a picture of a polar bear in earmuffs on skis for Cool and Fresh. Well, there is a way to search for marks that have polar bears or that have animals on skis or so on, different design elements, as we'll see in the next slide. So this is what we do. If we go to the home page and click on trademarks in the blue bar that goes across the masthead, selecting manuals, guides, and official gazettes, this time we're going to select something called the Design Search Code Manual. Now, I know today you've heard a lot about classification. Well, this is another way to classify things. But what we've done is we've created all design elements, both literal and abstract, and we've broken them down with codes for all those different design elements. So if we click on that link, we can do a keyword search. And if you click on that, we can put in polar bear. We can find out what code, what numerical code there is, if there is any, for polar bears. In doing so, it pulls up this list, and not only did it look for polar bears, it all looked for any choice of the word polar and any choice of the word bears. And we find out that 03.01.14 is a number we can use to input in our search that will pull up polar bears. It also will pull up, as we will see, some other types of bears like koala. It's a code that has different types of bears involved in it, grizzly bears and koala bears. So, but nonetheless, this is a code we can do to pull up marks that, after all, only have graphic elements or in part have graphic elements. Now, on the next slide, we're going to enter those. I don't need to put in those decimal marks into test. So 030114 can be entered. And under the field code, and this is on the structured form search page, I'm going to select design code. I'm not going to end it with anything else. I'm going to click on submit query. And gosh, I got a lot of records. There are a lot of marks that have bear symbols in them, bear is somehow in them. And notice that fourth one listed there, though. It doesn't have any words at all, does it? It has a serial number, so that means that that mark has, while it must have the image of a bear in some way, it doesn't have any words with it. So you will see this when you do design code searching. Remember that example from the very first slide I showed you, the Chevrolet symbol, which is the famous kind of bow tie symbol. That has no words. It is only a graphic element. So there are graphic elements out there that are like that. Well, with 4,000 records, we don't want to have to look through these and figure out which ones are polar bears. Now, there's a few things we could do. There were other design elements involved with that polar bear, so we would try to see if there was a design code for earmuffs and for skis, and then and that would narrow it down quite a bit. Or we could also take this set and it with the international class that mouthwash fell into, which was 003. And if we do that, it doesn't show you the example. But you do that, it does narrow down the results quite a bit. And I do sometimes show different images of some of the different. That's okay. So what we've done here is show you that there's a multiple step approach in doing a thorough job of a trademark search. It is far more than doing an exact word search. It involves using some creativity and coming up with marks which are similar in sound, appearance, or meaning, where the goods or services are the same or related. So I hope you can take this example and apply this to your own mark that perhaps you are interested in using. Remember, don't rely solely on an exact word search, for you're likely going to miss potentially conflicting marks. And the final step we did, it's optional, is that there is a way to search for marks that have design elements. People ask, well, if they have words and if they have design elements, does anyone have prominence? It depends on the overall commercial impression of the mark as to whether that might pose. So it really depends on the mark. I think trademark examining attorneys generally look for the words first, but if you have a really strong image with the mark, an unusual image, a distinctive image, for example, for some things, let's say you were selling suntan lotion, it wouldn't be unusual to have a picture of the sun on your mark or to have like a sunset. But if you had, I think there's a suntan lotion that has a bullfrog on it. Well, that's distinctive. That's unexpected, and that makes for a more distinctive mark. So it really depends on the mark. And this is kind of just a reminder. If you're ever unsure, please feel free to consider talking to a trademark attorney. The U.S. Patent and Trademark Office does not have there's not a trademark bar type of thing where you have registered trademark attorneys. So the way you can find out if you do want to hire a trademark attorney, the Yellow Pages, the State Bar Association may have a listing of attorneys that are involved in intellectual property, and they may have a particular section for trademarks. There is INTA, the International Association of Trademark Attorneys. There are those ways to find, because you may need some guidance, expert advice, legal advice, perhaps additional searches from a trademark attorney. The one thing I showed you was doing a search on the Federal Register, but there are potential conflicts from the use of marks that are only used in state trademarks. I showed you the great thing about Arkansas Secretary of State's office is they do have a searchable trademark database for state trademarks, but some of the states do not. So you might want to hire an attorney to do state trademark searches, and also common law marks that might pose a problem can be searched as well by a trademark attorney. If you have further questions, feel free to come to this library, this Patent and Trademark Resource Center, talk to Michael Strickland and talk to the other good folks here, and they'll be glad to help you with your trademark questions. So, any questions about trademarks? Maybe we can get the microphone. This gentleman over here. Well, here's one right over here. I'm sorry. Bear with me. Thank you. Over there.
Now, from a strategy standpoint, how do you approach an acronym that's used in the name of a company that's become a trademark, like General Motors has a unique font and a unique graphic. But what if you come up with a company like General Merchandise, which will have a different font and a different styling? How do you approach to see that it won't have a conflict?
Well, the font is really not going to be a factor at all. In fact, if you look at well, I shouldn't say it won't be a factor at all, but it's unlikely to be a factor. In the Official Gazette, when you glance through the pages of the Official Gazette, you'll see two types of trademark filings. Some may have graphic elements, but many of these have what are called standard characters, block letters. The reason for this, it provides the trademark owner the option of making modifications in a font style. And you see this sometimes with companies. Over 10 years, 20 years, they go to a more modern look. But because they filed based on standard characters, that provides them with the option of just staying with that trademark registration. Some, on the other hand, may choose to file a new trademark registration showing that new look because they feel like it's distinctive enough and important enough. I think, having said that, I think an example that comes to mind, though, of an example where maybe a font style could be objected to would be if you have something that's really strongly associated with the mark, like the style with Coca-Cola, that font style, that kind of sweeping style. That would be something that if you were also selling soft drinks, people might mistakenly pick that, buy that thinking it was confusingly similar, and they would object to that. So searching for that, I really don't think there is a way of searching that style. It would just have to be caught by doing one of this due diligence of checking out marks in your particular field as they come out to make sure if indeed you feel like there's one that is confusingly similar to your mark. Now, regarding initials, initials typically, such as GM. GM is, of course, a well-known American brand and has over a period of time become very distinctive in the mind of Americans. But generally, if we were talking about initials being just letters of the alphabet, no matter the combination, typically are not very distinctive, strong marks, and that may be harder to defend because of that. Anything you want to add to that, Neil?
No, that's the main thing that I would argue myself, is what I'm kind of saying. But if it's a strong mark like GM, where the distinctiveness is there from history and everything else, you're going to have might have a problem with that. The other example I will give you is a mark. You know, every company is going to really enforce, especially the marks that they have, as much as they can. And one company that's out there that polices their mark in big ways is McDonald's. McDonald's, the distinctiveness of McDonald's is so well known now. And there's an example that I know of from, my sister used to work for Diebold that put in ATM machines, and she was working in, just in the state of Michigan for a while, and then she went more nationally with Diebold. And there was a small bank in the Thumb area of Michigan that had a Scottish name, and when they went to an ATM service, they were thinking of calling it McCash. McDonald's came immediately after them and said, you cannot use that mark. So, you know, it depends on the distinctiveness of the mark and how well known it is. So,
the catch with that is a factor that we didn't talk about, and that is famous marks are given additional protection. What is the term that's used with famous marks?
I think it's just acquired distinctiveness, right?
No, it's not just that. If you, the law allows for, with famous marks, that even though the goods or services are not the same or related, if the mark, and again, what's the difference between a mark that is famous or not famous? It's one of those things that has to be proven basically in court using examples such as polling and that sort of thing. It's one of those things that you see that if you know one. But anyways, that is not a factor, by the way, used by the U.S. Patent and Trademark Office in making decisions as to confusingly similar, but it can be brought up at a later date if a mark is considered a famous mark. Any other questions? Yes?
I have two. Actually, you may have been referring to goodwill when you were talking about a famous mark and why they're given additional precedence. There's a bit of a goodwill they've built up. Anyway, in terms of my questions, you referenced the intent to use and that you had up to 3 years to actually start using it, and you had to apply or reapply for it every 6 months. Is there a fee for every time that you reapply?
Yes, there is. I think it's about $100, and it's, I would check that before. And it's also based on how many international classes are involved.
Right.
So that can add up over every 6 months if you keep extending that out. But ultimately, you can't keep sitting on that mark for that type of good or service. You have to abandon it if you're not using it.
And the second question has to do with Riviera, Buick, and all of that. So in the case of Buick not having used the Riviera mark for some period of time, if they in essence abandoned the usage of Riviera and also abandoned the filing of, for that trademark, could somebody pick it up?
This question comes up a lot in libraries, and that is someone may have remembered a product or service that was sold 20, 30 years ago. And it's kind of like that slide I said there about showing the tombstone. If a mark's dead, can I use it? And the thing is, you want to make really, really sure that it's truly, truly dead. For example, in the Mid-Atlantic states, one of the competitors in the home improvement area was what was the company called? I want to say Hex, but that's not right. That was a department store. It was Hechinger's. Hechinger's was the name of it was a well-known home improvement company. Well, Home Depot came along and became very popular, and they went out of business. And someone wanted to use the name Hechinger's, which still had some goodwill associated with it with people from the Mid-Atlantic area, but they wanted to establish a website in which they sold home goods, that type of thing. But they did contact Hechinger's first, and they made sure they got the rights to it before they went out and did it on their own. And that's one thing that's worth considering. Another thing worth considering is even if a mark is truly continues to not be in use, there could be another type of intellectual property protection involved, and that's copyright. Copyright is used in things like advertising, and copyright, unlike trademarks, has long life. And so again, that's another area where you'd want to hire an attorney to make sure that there were no rights involved, or maybe in the case of Hechinger's, the Hechinger family was happy to license the rights. So it doesn't mean you can't use it, but you want to make sure that everything is cleared before you use it.
Yeah, and Tom, you were just mentioning something else. Earlier, Tom had mentioned the idea about Buick coming back with Riviera. Well, Riviera has not been a mark that's been used for a very long time. I come from Detroit area, and I know a little bit about the auto industry, and the companies respect each other. They're not going to go and say, oh, well, GM's not using Riviera anymore, so Ford, is going to go along and say, I'm going to produce a car with the nameplate Riviera. They're not going to do that because they respect each other, and they know that, okay, this is in your bank, this is kind of where you're at, and so forth, so we're not going to interfere with that. And just like there are certain vehicles, like the Ford, you got the Ford Falcon, you got the Mustang, so it's kind of a theme there, and so they're not going to try and infringe on that theme too much either.
But the other thing is you don't want to have a third party to come up with Riviera Auto Scent things, because because that is such a strong mark, they might think there's an association with General Motors from that. So
Sure, exactly.
again, you always run the real risk if you have a famous mark of trying to copy it. And if we can provide advice, we're not supposed to provide advice, but if we provide advice, try your best to stay away from famous marks, because again, there's this built-up goodwill, and you're likely to be sued. Any other questions about trademarks? Yes, your question over there, sir.
What is the significance of the TM next to some of those?
Right. I mentioned that earlier, and that is the small TM symbol or the small SM symbol is your way of showing that you're using a mark, that you're identifying to the rest of the world this is used as a mark. While it may be used on, the TM symbol is used for goods, a small SM symbol is used for service marks. But while it may be used if you have a pending application with the USPTO, you don't have to have a pending application with the USPTO. In the case of unregistered marks, those so-called common law marks, it's your way of saying to the rest of the business world, I'm using this word as a mark. It's being used in commerce on my product as a source identifier. And that's what it is. And if you ever need to go to court later on, and you can go to court and sue infringers, even if you have an unregistered common law mark, that's your proof right there, the fact that you put out products, and you can show that you had packaging that had the TM symbol, because that was telling people. The value of registration, of being on the Federal Register, is that's like a public register which everybody can see, and that's proof up front of your ownership of that mark. And that's the benefits of federal registration.
It's additional proof then.
Additional, correct. Okay, and is there one more break associated with this, Michael?
Yes, we're supposed to have one more break.
Okay, well, let's take that, and then
a very
we'll,
short break.
and then we'll talk about Pub West, and that'll be it. And we tell you that all of these presentations you've seen today and tomorrow you will see are going to be archived on this www.arcapital, that's AR capital, .com, or specifically, the company that's doing this, www.livestream.com/connectar for Arkansas TV, Connect AR TV. So we wanted you to be aware of that. Please remember, so Neil's going to go through, everybody has a copy of the presentation on PubWest.
You should have this copy that says PubWest Patent Databases for Power Searchers, okay? And so I'll go over a little bit of these slides. I'll tell you what slide I'm on so we can all be kind of together a little bit. Well, let me explain a little bit what PubWest is and what PubWest isn't. PubWest really isn't a database so much as it's a portal to other databases, okay? And it's a public version of a web-based examiner search tool, okay? It has nothing to do with the Westlaw people or anything, or it doesn't have anything to do with a direction east and west. It's just an acronym for web-based examiner search tool. It was developed initially by the USPTO for our patent examiners, and then we began using it in the public search facility. And then after a little while, we wound up being able to also provide it to our patent and trademark resource libraries as well. So you do have the opportunity to use it here as well. Now, the main thing to keep in mind with PubWest, whether you are using PubWest or not, the 7-step search strategy that I was talking about initially still applies, okay? You still want to describe what your invention is. You still want to go through and think of the synonyms. You still want to go through the index, find the classification, look at the manual, look in the definitions, and do all the steps that we already initially talked about this morning, okay? PubWest just allows you to do it a whole lot faster, and it allows you to do some things that you cannot do on the database that's available to the public. All right. On the USPTO website, right, okay. So again, like I said, it's available in the public search facility at the USPTO. It's also available here at Arkansas State Library. All right, well, what does PubWest? I said PubWest is more of a portal to databases than a database in and of itself. If you look on page 2 of your handout on the bottom, you will see that of the databases that are available on PubWest, we have the U.S. Patent Full Text Database. And remember what we said about the database at the USPTO website? It goes back to 1976 for text searching. PubWest actually goes for text searching back to 1971. All right, we also then have the pre-grant publications, just like we do on the database on the USPTO website. But notice we also happen to have 2 other databases here called EPO, European Patent Abstracts, and Japanese Patent Office Abstracts. These are abstracts of patents and patent applications from European countries and then also from Japan. So you can search on those. Now, if you're doing a text search, all you're searching on is the abstract, okay? Abstract in the title. You don't have keyword searching of the entire text of those patents because those are going to be in the language of the original country. But we do have an English abstract of those, and they are searchable. We also notice, if you see, we have what's called an OCR patents database from 1975 to about 1900 plus. In the office, we wound up doing an optical character recognition of the patents that were not in machine-readable format. And we went back to about 1920, and we actually found out that we actually took, in some particular classes, we went actually beyond 1920. So you can do a text search in those, in this OCR database for patents going back up to 1920, and in some cases a little bit beyond. It is not clean data. It's very, very, it's based on the recognition of the software of what might be an old patent with you know, the legibility of the ink coming away and so forth. And if it couldn't read a certain character properly, it's going to throw in other characters as well for you. So the letter A may turn out to be an @ sign or something like that, or et cetera, et cetera. So it's not always clean data, but you can do some searching on that as well. And then we also have a foreign document retrieval system which allows for finding other foreign patents pretty much based on patent number of other countries that are not just in the EPO. I can find patents from China there. I can find patents from the old Soviet Union and Russia and several other countries as well, and Canada as well. But basically that one is foreign patents that are on file in the, we have what's called the Scientific Technical Information Center that has a foreign patent collection, and it's really those foreign patents that are on file there. All right. I said that, and I'm now on page 3, I said that PubWest is a whole lot faster. It is a whole lot faster. The speed by which one can go into PAT-FT, doing PAT-FT or AppFT, you saw on the slides that I was showing you earlier about that you had the hyperlinks to each patent, and you had to click on each one of those. Well, guess what? On PubWest, if you do the search, first of all, you get to do the search simultaneously in AppFT and PAT-FT at the same time. All right? So you don't have to do one search in one file and then repeat the same search over in another file. You can do them simultaneously together. The other thing is that once you have the complete data set, the images can come up immediately, and you can go from one patent right to the next patent. Boom, 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 boom. All right, so it's a lot faster viewing. The other nice advantage on the PubWest system, I did not mention this earlier, but if on the USPTO website if you have a patent that you're looking at and you want to make print copies of it, it is page by page by page. On PubWest, you can do it with one click and you can print the entire patent out. I don't care if it's 50 pages or just a couple pages. So it's a lot faster that way as well. All right. So we said it's faster printing. Okay. Okay, you also have a little bit more precise searching. On the USPTO website, the only way the operators that you have to be able to use are and, or, and not. That means you are searching the entire database for the two words wherever those two words appear anywhere in the document. So if I was searching airbags, for example, okay, I would put in air and bag, and air could be over here someplace, and bag could be several pages away, and it will bring up that patent because the two words are together. It's an and situation anywhere in the document. However, in PubWest, I can use something known as proximity operators. And so I could say that I want air immediately adjacent to bag, where air and bag are, air precedes bag. And I can get all the patents that come up where air and bag are immediately adjacent, and I'm not looking at something that's over here and then something else that's over here. So that creates a lot better searching all by itself in that way. All right. The other nice thing that I can do in PubWest, I can look at keyword in context. So if I'm looking at my patent, I want to see where, and I've done a keyword search, I can now look at the keyword in context and find out where in this patent these words that I'm searching are coming out, and I can get a small little, maybe 7-line paragraph showing me the context by which those words are used. That helps a whole lot too, because now I can see, does this really relate to what I'm looking for or not? All right. You can search by L numbers. If you're on page 5 on the bottom screen, I've done a search L2 ball or baseball or projectile and reflecting. You see the truncation symbols with the question marks, or shiny or fluorescent. And you see I got a rather large subset there of 28,000 documents, almost 29,000. And then I'm just doing L2, where I don't have to repeat all those words all over again, and I'm simply saying, and not computer, and I reduce that number. I still don't want to really look at over 20,000 documents, so I'd probably really want to bring my search down quite a bit from there, but it's an example of how you can bring that down in reusing L words. All right. Faster searching using multiple databases. I said before, I can search simultaneously in the patent full text database, and I can search in the granted patents all at the same time. So I'm seeing everything all at the same time. I don't have to do the same search repeatedly in 2 different databases. That saves up a whole lot of time. There are more patents, exactly as I was just saying, in the USPTO database as well. There's the OCR file that I was just talking about. The patent coverage is a little bit different. OCR, it says here on page 7 that we go from 1836 to 1975. 1836, again, remember this is hit and miss. Basically, the OCR database is from 1920 to 1975, but there are some that go back beyond 1920 and some that go back even earlier in the early 19th century, so you can use those as well. And up at the top of that one, you see actually the patent image of Lincoln's, Abraham Lincoln's patent for a boat using a means for getting over shoals in a river, okay? Abraham Lincoln is the only president in the United States granted a patent. All right. Okay, you also have, again, I mentioned that you have the EPO abstracts and the JPO abstracts, so you can search the foreign databases as well. And that can be very useful because, again, that can become part of the prior art. All right. Remember when I'm talking about EPO and JPO abstracts, I'm talking about abstracts and abstracts only, okay? It is not all of those, when you're searching in the abstract, basically what it's telling you is not that this is absolutely a direct hit on what you're looking for. It might be if you're doing a keyword search, because all you're basing it on is the abstract. But if it looks like it's important to you, you'd probably still need to get a translation of it and pay the money for that, but there's ways of doing that as well if you needed to. But the abstracts just serve as a way of being able to conduct the search and find out what it's about and get a general sense, is this something close I might need to take a better and more comprehensive look at. All right, the years of coverage for the EPO abstracts. We have 5 countries right now that are in the EPO database. Those are Switzerland, which is the country code for that is CH. That starts in 1978. Federal Republic of Germany starts in 1982. France begins in 1982 as well. Great Britain starts in 1979. We have the European Patent Office beginning in 78. And we have the World Intellectual Property Organization starting in 1979. Japanese abstracts begins in 1976. So those are the years of coverage for those databases. The foreign image database is not really part of PubWest per se. It's not the same thing as EPO. It's not using the same logic, Boolean logic or proximity operators that we would normally use there. It's the foreign database. PubWest actually acts as a gateway to this foreign database, which are the foreign patents of our Scientific Technical Information Center, okay? And there are over 32 countries that are listed there in the holdings, and again, you can search by patent number, and so if you had a patent number that you said, boy, I know this country has, there's this patent number and you're searching for it, you can put in the number and it will bring up every country that has that sequence of numbers to it. And then you can find the country that you're looking for that way. And you see that on page 10, on the bottom of page 10, how to do that search. Again, you don't have to worry about leading zeros or country codes. You just type in the number and it shows you the various countries with that numeric code, okay? And on page 11 on the bottom, you see one patent that came up with, which happens to be from France. All right, let's see what else we have. All right, again, why are foreign patents important? That's on page 12. Again, it goes to this novelty area that both Tom and I talked about earlier in the day. If the patent has already been done, if it's been disclosed, you cannot get a patent on it again, regardless of whether it was patented on the, okay, Tom's telling me to hurry up, so, all right. So, there is an initial destination for PubWest, that's on the bottom of page 12. You can search other forms. There's a free form search, there's a structured search, a classification, dictionary search, a thesaurus. The dictionary search is wonderful also for being able to search an inventor's name. For an inventor's name, I might not know if the inventor is using his middle initial or not, and I can go into the dictionary and find that, and I can find all the variant forms of that inventor's name. Same thing for the thesaurus, for looking for a company name and finding all the variants for a company name as well. So it's very useful that way as well. Let me speed up here a little bit further. There's a structured search, as you can see, for doing classification searches. And here you get an idea on the bottom of page 14 what that menu is going to look like. This is a side-by-side display. It's showing you some of the references and then bringing up one of the images. And like I said, the images come up very quickly. There is also, on the top of page 15, there is a grid that was just made available in the last few years on the PubWest database. And that grid allows you to be able to do your search and then download that search into a Excel spreadsheet and take that Excel spreadsheet home with you, and you have the list of the patents that you've been able to look at or searched. It'll give you the patent number and some of the small bibliographic information as well. You'll notice also that there is something called on the far left-hand side, on the top of the column, it has App FLT, that's an application filter. There's a means by which, in fact, one of our libraries called just last week and was asking, they had a searcher who was trying to find and look for applications that on a particular area where the application had not proceeded on to being a granted patent. They were wondering if they could do that in the AppFT database on our patent website. And there's no way you can do that. However, in PubWest, there is a way that you can do that using this grid, and you can search on it, and that app filter will give you, wherever there is an application number with a patent number, it will give you the application number with a +1 to say that, guess what? If you click on the +1, you'll be able to see the patent number as well. And so there is a way of being able to screen for that. Yes, sir, you got a quick question?
Yeah, so it sounds like there's a lot of things that PubWest can do that the USPTO website can't do.
Absolutely.
So why use the USPTO?
Well, the PubWest database is available. It's not available on all the databases and computers here, whereas on the PTO website one, you can do it from home as well. So it depends on what you're looking at and so forth. You can actually get started on the USPTO website and go in, and then if you find out that you need some other features that you really want, then you can go into the PubWest, okay? So, like I said, there's the grid, and it shows you how to use the grid and then download that to a spreadsheet, all right? And you can then customize those columns, and there's a free-form search as well. Again, with the free-form search, it allows you to do several things all at once, but you do have to use field codes, and the field codes are made available for you to be able to do exactly what you want. But those are different ways of being able to combine it. Notice on the bottom screen on page 17, there is a combined search, so I'm combining. Not only can I combine now the class, both the US PAT database and the publications in one single search. Notice that I can also combine more than one class and subclass at the same time as well, something that you cannot do on the USPTO website database, okay? Then you have the search syntax, so I can say, let's say on page 18 up at the top, if I know that my inventor is in Little Rock, I can do Little, ADJ, Rock, and Arkansas, where it's the inventor state, so I can find all the people who have been inventors from Little Rock, Arkansas, and I can get the whole list of the people that way as well, okay? Interestingly, you need to have the ADJ there. If you do not put the ADJ there, and you just do Little Rock, the USPTO database, what it's going to do is going to look for Little anywhere in the document, and Rock where Rock is the city name. And so you wind up with a whole lot of patents that way, but none of them relate to Little Rock, believe me. Boolean logic operators, we have something called AND, OR, and then not. There's something called XOR, which I not found a good application for. And then you see the proximity operators of ADJ and near, and notice that there's an end variable where I could put a number, so I could say ADJ3, where the terms could be up to 3 words apart from each other. And then we have with, where the terms are in the same sentence or in the same paragraph. And that is the summary, and that is it. So any quick questions or? Oh, they do? Oh, well, you guys, I guess have to get out of here.
We appreciate you not only taking your time and your patience with us. We thank you so much for coming by today. Feel free to check the good folks here at Arkansas State Library if you have additional questions, and we'll be glad to provide support to anything.
And please hand in your evaluations as you leave.
Yes.